another matter, my lord, has been listed before another court, my lord, connected matter, my lord. Can it be taken up on Friday, my lord, along with that with petition, my lord?
3940,
My
that
lord.
principal selection.
My lord.
Yes,
So why? What is the other matter?
WPC 2371/2026.
Oh, who has filed that?
That was filed by me, my lord.
For?
I was during my lord, stay of why I was working, my lord, I was transferred to another school. That order is under challenge.
But in that case, my
Okay.
lord,
Okay.
in that case, my lord, I
Stay is there.
There is no stay, my lord.
Here your very eligibility has been questioned. We forget Farooq Abdul Salman Habib. He has a criminal case against him.
I am Farooq Abdullah.
You are Farooq. Okay. Then rightly so, they have transferred you. POSCO allegation.
No, my lord, that allegation is not, for that allegation, they have not transferred me, my lord.
No, fine. But here there is a POSCO allegation against you.
My lord,
Minus students.
on the basis of POCSO allegation, my lord, I was placed under suspension. I was reinstated. In the reinstatement order, my lord,
They have posted you. Ajay Chaudhary, para 21, below part.
no, my lord,
They can do that.
What they have, my lord, what this honorable court observed, my lord, while taking up the, my lord, writ petition, challenging the, my lord, suspension order, this one, the BTC authority, my lord, they sought for leave to proceed against the petitioner. This honorable court, my lord, declined that, my lord.
Why a leave is required? Why a leave is required?
my lord,
You
alia,
have, Mr. You have been suspended.
I was
You have
suspended.
been, after reinstatement, you have been posted in some other place.
No.
Very well.
yes, my
No,
lord.
Okay.
Thereafter, I
On
was,
the prayer of Mr. I.H. Soikya, Learned Counsel, for the petitioner in WPC number 627, 2026 and respondent number 6.
my lord.
Respondent number?
6
6 in WPC number 595, 2026. The matter stands adjourned. Registry to list these matters again, along with WPC number
2371/2026.
2371, 2026, next week, after a week.
My lord, date may be fixed.
That
my
may
lord.
pass.
June. Huh? On 15/6, 2026.
My lord.
Obvious.
Obliged, my lord.
May it please your lordship, I filed an additional affidavit. That will be kindly call for. Deeply.
They have
obliged.
given you the salary?
No, nothing.
Not now?
Nothing.
Not till now?
Not till now.
What happened after the document verification? That
Documents-
is so late?
They have again called for some documents. The director has written it to the elementary education, secondary education, that we need these 2 documents. However, the fact remains that those 2 documents are well in the writ petition. In spite of that, they have called again for these documents. I have deposited, but they have not given a receiving once again.
Who is appearing for the respondents?
It was P.
Secondary
Datta.
education.
It was, P. Datta appeared last time.
Mr. Sharma, have your instructions on that. Give him a copy. When the matter is taken up, I want the instructions.
Deeply obliged.
May it please your lordship. His lordship, with the consent of the other side, my lord, I beg to mention item number 24. My lord, may kindly fix the matter on 11th, my lord.
Why?
Lordship, learned AG sir is leading me in this
Huh?
matter. Learned AG sir is leading me in this matter, lordship. He has taken consent from the my learned senior, my lord.
On Thursday, my lord.
Thursday, 11th.
It will take some time, my lord. The argument will take a little
Do you think it will take time?
bit. Subject to your lordships.
On the prayer of the Learned Council, on the prayer of Miss M.D. Bora, Learned Standing Council, Transport Department, registry to list this matter again on 11/6/2026. The prayer is above, the order is passed in presence of Mr. B.D. Goswami, Learned Counsel for the petition.
Much of
Obliged, lordship.
May I please, your lordship? Lordship, on item number 20, your lordship.
20.
Yes, lordship. Where is the conducting counsel of P. Bhattacharya is appearing, lordship?
Oh, registry to list this matter before any other bench without me. Yes.
May it please, my lord.
Hmm.
My lord, I beg to mention item number 23 of the daily list. My lord, I'm praying for a week's time to file the affidavit in reply to the affidavit in opposition filed by respondent number 1 to 5 and to the affidavit in opposition filed by respondent number 6. May the matter be listed in the next week, my lord.
A prayer is made on behalf of Mr. D. Nath, learned counsel, for the petitioner
Yes, my lord.
for an adjournment in the matter to facilitate filing of a rejoinder to the affidavit filed by the respondents. Registry to list this matter again on 16/6/22. Any issue?
No, my lord, there was an interim order passed.
The affidavit, the rejoinder be filed before the next date of listing by the petitioner. Interim order passed earlier to continue till the next date of listing. But how do you bring these CCS rules into operation here? 21 rules. You are an NPS. Your son was an NPS, covered under NPS. Daughter, sorry, was
Yes.
covered under NPS.
Yes, my lord.
Huh?
Yes, my lord.
So NPS is that person's own declaration. You have been given 30%? No, 35%.
35%.
Husband has been, the
30%.
husband, your son-in-law has been given 30%.
30%.
And your husband has
Yes,
been given 35%.
35%.
There is still till date no proceeding finality attached to the allegations, criminal proceedings which have been drawn up against the husband of your daughter,
Yes, my lord.
right?
Yes, my lord.
In that situation, how can we come in at this stage?
My lord,
and,
let me file the affidavit. And
Okay, file the
we will bring our stand on record.
Okay. Respond number 7.
Obliged, madam.
Okay, fine.
Lordship, item number 57, Lordship. Supplementary admission, Lordship. I am for the respondent number 7, Lordship. She has expired, Lordship.
Oh.
I could not inform Mr. M. Datta, Land Counsel. of the
Inform him.
petition.
Come
Lord-
back.
Lordship.
You disown to be your daughter, even your daughter of your husband,
Yes,
Huh?
yes, because she has,
Counsel.
yes, Lordship.
and the daughter of the petitioner is staying with her or with somebody else.
No, original 2 daughters. They are
The
married.
daughter of this petitioner, you say that she was married and she has a daughter, right? Where is she staying? Where is
Is,
that?
to the information of the petition, respondent, Lordship, she is staying at Gauhati, Lordship.
She is staying at Gauhati,
Gauhati.
not taking care of the mother. She's around 24 years.
Yes.
Let the matter reach.
Yes, yes.
Yes. I think we should pass the order. That's all. Anything more? Where is Ms. Gayan? I want that sheet. Anybody representing Ms. Gayan here? Mr. Biria,
Yes,
can you get hold of Ms. Gayan? I just want that paper wherein that DG has granted that approval. I asked her to give me a Xerox copy, but she has not given me a Xerox copy. Just get hold of her. I'm sorry,
Sure.
because if we interfere with this today,
Your lordship may kindly hear me then.
Huh.
Because your lordship on last occasion,
I declare that law. Let me say I declare that law.
on last,
Then 77 candidates, or sorry, 67 candidates or 77 candidates would be condemned unheard.
but their appointment itself is illegal.
Forget it. I'll have to hear them. Can I
No,
pass
no,
orders?
lordship, there is no need to hear them.
Why?
Because the Supreme Court says it.
Show me which Supreme Court judgment says it's not to be heard.
Whether it is necessary to hear them or not. Because even if your lordship, they were present before your
This is different, Mr. Counsel. This is different.
lordship, it was similar matter.
This is
wherein
different.
The high
This is, court says that once a declaration is made that appointment is vitiated.
Yes.
In that circumstance, You need not hear, but
Yes.
without they being here, how can they have at least a right.
No, your lordship. Issue
Oh,
number
Mr. Beria, they have a right to argue before this court that the
But what-
relaxation was given correctly.
But what defense possible? What possible
That's
defense?
the only defense. That's the only defense. You
Your
can't
lordship,
argue on that.
no prejudice would be caused to them.
They will be cost, they'll lose their services.
But your lordship, at first
Appeal.
point, they are not eligible to be
Appeal,
appointed.
appeal. Okay, reserve that for your appeal. Mr. Beria, this court cannot just close down its eyes.
Your lordship,
If you
there
had
is no
made
fault
them,
of
if
mind.
you had made everyone, at least in representative capacity, party respondents, other than that,
Respondent of
Uttarakhand
Savage
was-
in representative capacity.
Oh, no,
Lordship,
you have
and
not, you have
the
not.
advertisement itself segregated. Your lordship may kindly peruse the advertisement. then.
Okay, you get hold of her. We'll see. Next. Yes, Mr. Soikia.
My lord. Well, what happened, my lord, after the judgment, my lord, in the writ appeal,
Hmm.
three,
Now, first tell me,
my lord,
the selection is of
is of,
2009
yes,
and you came before this court in 2020.
my lord,
By that time, the appellate court had already,
my lord.
what is left here?
Yes.
Nothing.
My lord, the one review petition has been pending.
Oh, forget the review petition. You don't get it because of the delay.
No, but since the review petition is
I'm
pending.
sorry, even if that review petition is allowed, your case will be dismissed because you have come. You were a fence
Let
sitter.
the, my lord, review be
No.
allowed or dismissed, my lord. Then
Whatever it
consider
happens,
my case,
happens,
my lord.
happens,
That
happens.
is my simple prayer, my
No.
lord. Kindly do that.
You are not a party to that review petition, Mr.
No, my
Soidan.
I am not that part.
And you never came up before this court assailing that immediately thereafter. You waited for maybe 11 years before this.
My lord.
Uh,
My lord, my only prayer, my lord, kindly postpone the matter till the review is.
I'll take it up. I'll
Thank you,
incorporate it. But Mr. P.J. Soikia, learned counsel for the petitioner, also heard Ms. M. Bhattaji, learned additional senior government advocate, appearing for all the respondents. The petitioners, by way of instituting the present writ petition, has presented a challenge to a select list published on 27/11/2010 with regard to recruitment against vacant posts of constables as advertised. Wide the advertisement dated
So dated, my lord.
8/2/2010,
Yes.
more specifically for the district of Gulaghat.
Yes,
Gulaghat.
yes,
So, in pursuance to the advertisement dated 8/2/2010, the petitioners had submitted their respective applications for recruitment against the post of constables (Ambanj) as notified for the district of Gulaghat. It is to be noted that the advertisement had required submission of such application by the inhabitants, by the candidates to the extent against posts reserved for the district to which they belong. On completion, the petitioners further contend that they have completed all the stages of the selection process. However, on the select list being published on 27/11/2010, the names of the petitioners did not find mention therein. Also, it is seen that after the publication of the said select list, which has a validity of a year, the petitioners are not found to have assailed the same before this court by way of filing by approaching this court and or approaching the respondent authorities.
may I submit something? During that period, my lord, there are similar repetitions were pending, my lord.
Oh, similar doesn't mean that you are there.
10 lordship.
You are right.
My lord.
You have to come. Also, Mr. P.J. Soikia, learned counsel for the petitioner, has submitted that persons similarly situated like the petitioners belonging to Sibsagar district had approached this court alleging similar allegations as alleged by the petitioner in the present proceedings. The said writ petition was considered by a coordinate bench of this court and while order dated 22/2/2019, the coordinate bench having found that the petitioners therein had all acquired marks above the cutoff marks as obtained in the selection process, however, they being not appointed, proceeded to direct the respondent authorities to appoint the petitioners against the next available vacancies. It is to be noted that the coordinate bench had not interfered with the appointments already made from the select list as prepared for the district of Sipsagar. The state authorities being aggrieved by the said selection, had approached this court by way of the petitioners themselves went, no?
No, my lord. State.
Statement had approached this court by way of filing a writ appeal, being writ appeal number 50/2022. A division bench of this court.
Lordship, there were two writ appeals, one filed by the Palash Fukan and the others, and another by the preferred by the state of Assam.
50
Lordship.
was state,
Yes,
50
Lordship.
of
50 by
2022 was
Yes,
preferred by
Lord.
the state. Also, a division bench of this court considered the said writ appeal along with a writ appeal filed by a writ appeal being WA number 323/2021 filed by the aggrieved petitioners in by the petitioners in WPC number 2725/2010. The division bench of this court, while order dated 12/6/2024, proceeded to proceeded to allow the writ appeal being writ appeal number 50/2022 filed by the state, thereby interfering with the judgment and order dated 22/2019 passed by the learned single judge in WPC number 2725/2008. Also, the petitioners in the present petitioners have instituted the present writ petition only on 27/11/2020. That is after the passing of the judgment and order dated 22/2019 in WPC number 2725/2010. Also, the petitioners are not found to have approached this court during the validity of the select list in question. The select list in question having lost its validity on completion of 1 year from the date it was so published, that is 27/11/2010, the present writ petition would not be, in the considered view of this court, would not be maintainable. Further aspect that is to be noticed is that while the petitioners have filed the present writ petition after the publication of the select list, they have not made any of the selected candidates a party respondent in the present proceedings. The petitioners have only relied upon the decision of the coordinate bench in WPC number 2725/2010 to advance their case. The petitioners in the present writ petition have also not brought on record any material to show that they had acquired more marks than the selected candidates in the selection process. Also, the petitioners in the present petition are found to be fence sitters, and accordingly, on account of the delay occasioning in instituting the present writ petition assailing the select list dated 27/11/2010, this court is of the considered view that the claim made by the petitioners in the present writ petition would not mandate an acceptance by this court. For the reasons assigned herein above, the present writ petition stands dismissed. However, dismissed. Present writ petition is found to be devoid of any merit, and accordingly, the stands dismissed. However, there would be no order as to cause. Sorry.
No, so far review petition pending before this division bench. my lord.
That you happen something, you go up on appeal, tag it with that. Sorry. Mr. Soikia, after 11 years, we can't permit. Yes, who is appearing for the contemners? Next,
Item number 5. my lord. On
Aye. Material. Type to material. You are there. What is there now here? No violation.
Right. But the
You are
order,
against the order passed by the coordinate bench.
my lord. Order
But that
dated-
order is following the 2725. That is no longer there. So this is also no violation as on date. But Mr. P.J. Soikia, learned counsel for the petitioner. Also heard. Ms. Vachaji, you are appearing for the respondents?
I can appear, but here no name is shown.
Oh,
Lord
forget.
Mayor.
Also, the present contempt petition has been instituted alleging violation of the directions passed by this court while order dated 22/5/2019 in WPC number 3261/2019. Also, this court while order dated 22/5/2019 in WPC number 3261/2019 had directed the respondents to consider the case of the petitioner in line with the had in line with the directions passed by this court while judgment and order dated 22/2/2019 in WPC number 2725/2010. Also, Mr. Saikia has fairly submitted that the decision of this court in WPC number 2725/2010, which was directed to be followed by this court while the order dated 22/5/2019 in WPC number 3261/2019 on an appeal being presented against it by the state in WA number 50 of 2019, a division bench of this court while order dated while judgment and order dated 12/6/2024 had interfered with the said judgment. Also, in view of the judgment and order dated 22/9/2019 passed in WPC number 2725/2010, having already been interfered with, there would arise no occasion for the respondents to implement the already set aside directions in respect of the petitioners in terms of the directions passed by this court while order dated 22/5/2019 in WPC number 3261/2019. So accordingly, no violation of the order dated 22/5/2019 is made out, and accordingly is made out. Full stop. Consequently, the present writ petition stands
Condemned.
closed. The notices issued stand recalled.
Always.
This is that
Yes. No, my lord, it is not pertains to, my lord, that
series.
no, it pertains to the series, but my lord, not directly connected to the, my lord, petitioners if Dibrugarh and
Miller matter.
I had
Yes,
made extensive submissions
yes.
when I was that side.
otherwise I am relying upon the compilation only, my lord.
Raise free to list this matter before any other bench without me. Because that thing is
Yes,
inside,
yes.
no? So why should I?
My lord.
Not once,
Yes.
many rounds.
I was also hand over one file.
To me.
Yes.
See. Was
Oh,
the MI along with it or without only a file you gave me? Or the MI also?
Only file.
Only file.
Only.
Yes, Mr. Das.
My lord, here that the other side has filed an affidavit, my lord.
Oh, when did he die?
My lord, that my lord aspect was not clear. My lord.
Then forget it. You go before the tribunal, establish your right. Not before this court, with this.
Only my one humble submission is that I'm not, if my lord, my school was not, my lord, that.
How many teachers were provincialized? 3.
Two teachers, my lord.
How many
One.
teachers were provincialized?
2, my lord, that
Toran Chandra Nath and Ayoram Nara. Any case filed by Pradip Nath, you are Mili.
my lord.
Pradip Nath, any case filed?
No, my lord, he has not filed any case. Pradip Nath is the headmaster. My lord,
He has not been provincialized.
not, my lord, no, not provincialized. Only here, my lord, only my one.
Yes. Mr.
Lord-
Sharma.
Lordship, there are 2-3 things. One is that the school, which was supposed to be provincialized, it
not.
should have been recognized prior to 1
Have you cancelled it? Have you cancelled it?
That particular instruction, I don't have.
That affidavit was filed.
Yes, affidavit has been-
16/5/26.
16/5.
And you have that material before you. You have not taken any call. And now, Mr. Sharma, tell me one thing.
Lordship,
Whether this Toran Chandra Nath is alive or not, you can know.
Lordship,
Huh? Why that has not been disclosed here?
here, Lordship, we have stated in paragraph 4,
Or that is with regard to
whether
the
16 are
that is with regard to the disclosure in the death certificate.
death certificate.
Death
For that,
certificate
we have written to the
admittedly
concerned
was
authority.
registered in November.
Lordship,
November 2018, and it was issued, December 2008. It was registered in date of issue is 5/12/2018, but while signing, he has written 5/11/2018. There is no registration is also of 2018.
Lordship.
So if this man is not there,
Lordship, here we have
and
already,
if he has been already granted the provincialization benefits, it cannot be because he is not there from 2016. Provincialization benefits is from 21.
Lordship,
2 o'clock. Get your instruction.
whether,
Whether Toran Chandra Nath was provincialized.
Lordship,
2, with regard to your contention that the school is not eligible,
Lordship.
whether any order has been passed.
Lordship.
Duta was that.
Lordship.
This case is for regularization, Lordship, but in this case, Lordship, there's a two categories employee working prior 1/4/1993 and after 1/4/1993. Therefore, Lordship, short accommodation may be given, Lordship, we will file affidavit.
Out of the petitioners, there are a set of petitioners who are working prior to 1/4/93,
1993.
and the other set is post 1/4/1993.
Yes.
And how come the secretary's case is attracted in your case? That will not be attracted. They are regular secretaries. This decision at page 45 will have no application. Yes, madam.
Ma'am, sir, may I plead your lordship? Lordship kindly pass over the matter for time being.
Time being. Okay, done.
In this matter, department has examining the matter, my lord. My lord, matter may be disposed of with the direction that within 2 months, it may be conclude.
Sorry, where is the instructions?
My lord,
Last order, 1/6/20.
yes, my lord.
Give me that.
That they are examining the matter, my lord.
What examination is required? These orders were passed in 2017 and 19, and you are sitting over the matter and filing affidavits before this court.
Actually, my lord, formal recommendation has been provided by the DSC, District Scrutiny Committee. So,
Yes,
my lord,
it has been forwarded. It has been forwarded by the DEO. I can show you from the records itself. I've gone through. I can show you.
but my lord, recommendation directly,
The
it is
District
not
Scrutiny
recommended.
Committee directed to refer the matter. The IS, DDC Mangalore has already communicated the matter to DSC, Assam, letter
Yes.
dated 2010-2007.
But recommendation is not there. The word recommendation.
Recommendation cannot be there. How can the recommendation be there when there is a doubt? That doubt clearance is being asked for. That whether it should be the respond numbers 7, 8 or the petitioner. That's all.
all the thing is the state level committee, my lord.
Ah.
When I go by the district level committee minus. That minus has created some doubt. So it was sent to the DSC, the director of health, director of secondary education. Now the state level committee will decide, my lord.
Whoever decides, we want the decision.
So, my lord, matter may be.
You have 1, 2, 3 hours. 3 hours is much thing. If I can read the file within 15 minutes, why 3 hours is required? Okay, Wednesday.
The matter may be disposed of with a direction.
I'm sorry, until and unless your director does not satisfy me on this, why the inaction, I'll dispose it with heavy cost if you want that. I'll dispose it off, but with heavy cost. Keeping 2 persons hanging for such a long time. Agreed?
No, my lord.
Then, Mr. U. Sharma, in pursuance to the query raised by this court wide order dated 1/6/2026 as placed on record. Communication dated, instruction dated instruction received from the Director, Secondary Education, Assam. So on a perusal of the said instruction, it is revealed that the director is examining the matter and has prayed for 7 days further time to arrive at a logical conclusion regarding the queries raised by the Jurisdictional District Scrutiny Committee in its meeting held on 18/11/2017 and 3/6/2019. So in view of the said development, a last opportunity is granted to the Director, Secondary Education to take a final decision in the matter. So registry to list this matter again on 15/6/2026 for further hearing.
My lord, this judgment I have brought Sukhendu.
Yes, one. Nothing remains.
But
Only my lord.
you have made a statement in the court, nothing remains. So I'll record that. So you're giving up that regularization by the board?
Yes, that
You're giving up?
that they disputed, so I am not going for that, but
Okay.
admitted fact is
Okay.
that.
Heard Mr. M.J. Borua, Learned Counsel for the petition. Also heard Mr. I. Bothaku, Learned Standing Counsel, Public Health Engineering Department, appearing for the respondents number 1, 2, 3, 1, 2, and 3. Finance. Also heard Mr. Get Mr. B. Gugoi. It will be a big financial burden on the state. Get him. B. Gugoi or anybody. Finance Department. What? 4. Okay. Also heard Miss M. Bora for the respondent number 4. Just get Mr. Borua, Mr. Bothaku, just get somebody from the finance department.
I want to place another judgment. Dharam Singh's financial burdens should not be in the.
Oh, this is a new chatka, recent chatka. Hey, Mr. Chalia, ready to open your purse a bit?
Lordship, Sudendu.
We are starting off with Sudendu today.
Lordship.
It's the Muhurat ceremony of Sudendu.
Yes.
Get me? Mr. M.J. Borua likhila hai. Also heard Mr. A. Chalia, Learned Counsel for the respondents. For the Standing Counsel Finance Department, appearing for the respondent number 5. The petitioners in the present petition has raised the grievance with regard to the authorities in the Public Health Engineering Department not recognizing the regularization of the services of the petitioners as effective during their tenure of service with the Urban Assam Water Supply and Sewerage Board. So, as projected in the writ petition, the petitioners herein were appointed as Khalasi cum Chokida in the work charge establishment, right?
Yes.
Work charge establishment under the Public Health Engineering Department prior to 1/4/1993, on various dates prior to 1/4/1993.
29/3/88, page 22.
All same day.
Same day, Malad 3.
On-
Page 22. Next one.
On 29/3/1988.
Yes.
Also, the petitions during their such service with the Public Health Engineering Department, came to be transferred along with this scheme they were so working, against which they were so working, to the Assam Urban Water Supply and Sewerage Board, bracket hereinafter, called the hereinafter referred to as the board for brevity. Also, The petitioners on joining the services of the board, comma, continued therein, and they were considered for regularization of their services. The work charge service of the petitioner came to be regularized. Work charge service rendered by the petitioners came to be regularized against grade 3 post, all grade 3.
No, my lord. One is grade 3.
Against grade 3 and grade 4 posts in the board. Also, as the petitioners were working as regular employees in the board, comma, they were again transferred back to the Public Health Engineering Department in the year 2011. Also, on joining the Public Health Engineering Department, the services of the regularization orders passed in respect of the petitioners by the board was, however, not recognized, and the petitioners were again required to work in the work charge / muster roll establishment. Also, the petitioners having continued in their services in the PHC department, comma, and you have all retired
Two petitioner number 2 and petitioner 3 retired.
before filing of the writ petition.
No. All are working when filing the writ petition.
Had approached this court by way of instituting the present writ petition, requiring, praying for a direction upon the respondent authorities to reckon the regularization of their services as occasioning in the as granted by the board during the tenure of their services with the board. Also, it is to be noted that during the pendency of the present writ petition, petitioners number
2 and 3
have already retired from their services on attaining the age of superannuation. Also, Mr. M.J. Borua, learned counsel for the petitioner, submit that the petitioners being engaged and in work charge / muster roll basis, work charge basis in the work charge establishment prior to 1/4/1993, their case for regularization of their services was covered by the policy decision adopted by the government in the year 2005. However, on account of the fact that during the said period, the petitioners were transferred to the establishment during the establishment of the board, comma, their services were not considered for regularization in the Public Health Engineering departments when persons similarly situated like them, when services of persons similarly situated like them came to be so regularized. So, Mr. M.J. Borua submits that on account of the dispute raised by the respondents with regard to the acceptance of the regularization effected in respect of the services of the petitioners by the board against grade 3 and grade 4 post, comma, he prays that he submits that he would not be pressing the said pressing the prayer made to direct the respondent authorities to reckon the said regularization effected of their services by the board for releasing to them their emoluments in the regular scale of pay, as well as to compute the pension and pensionary benefits in respect of the petitioners who have already retired. Having made the said submission, Mr. M.J. Borua has referred to a recent decision of the Honorable Supreme Court in the case of Sukendu Bhattaji versus State of Assam and others, reported in Assam and others, 2026 INSC 523. এটা ব্লক আউট করে দিবি। Also, per contra, Mr. I. Bothakur, learned counsel for the petitioners, for the standing counsel, PHC, Public Health Engineering Department, submits that the regularization of the services of the petitioner by the board during their tenure of service therein would be of no consequence, inasmuch as the board is an autonomous body and the service rendered by the employees of the board is not deemed to be service rendered in the Public Health Engineering Department. So, however, he submits that the petitioner, having given up the said prayer, no further consideration of the said issue would not be called to be made by this court. With regard to the prayer of the petitioner, that the case of the petitioner, learned counsel for the petitioner, that the case of the petitioners is covered by the decision of the Honorable Supreme Court in Sukendo Bhattchaji, bracket Supra. Mr. Bothakur submits that the respondent authorities be directed to carry out a verification with regard to the service particulars of the petitioners, and in the event they are found to be covered by the said decisions, a direction be issued to the PHC authorities to implement the said decision in respect of the petitioners herein. Anything, Mr. That exactly what I'm going to do. Oh, that is 96. So, I have heard the learned counsel for the parties and also perused the materials available on record. Mr. A. Chalia, learned standing counsel, Finance Department, submits that a verification is mandated to be carried out with regard to the service particulars of the petitioner, even in terms of the directions passed by the Honorable Supreme Court in the case of Sukendo Bhattchaji. I have heard the learned counsel for the parties and also perused the materials available on record. The petitioner, having not pressed the prayer made in the present writ petition for a direction upon the respondent authorities to reckon the regularization effected in their respective cases by the authorities of the Assam Sewerage Board during their tenure of service therein, the said prayer is not further considered by this court. With regard to the prayer made by the petitioners for regularization of the services in terms of the decision of the Honorable Supreme Court in the case of Sukendo Bhattchaji, this court has perused the decision of the Honorable Supreme Court in the case of Sukendo Bhattchaji and finds that the said judgment is squarely applicable to the facts of the present case. The Honorable Supreme Court in para 79 of the said judgment had passed the following directions, had drawn the following conclusions and directions. 79 to Kutko Ediba. So thereafter, the petition, the Honorable Supreme Court in para 96 proceeded to hold that the work charge employees shall be treated as a distinct class and their entitlement to pension and other post-retirement benefits shall not be adversely affected by the judgment made in the case of Upen Das and State of Assam versus Upen Das. So, the Honorable Supreme Court further provided a liberty to the members of the Appellant Association to agitate their claims for members of the work charge to the Appellant Association to agitate their claims for pensionary and other consequential benefits before the state government. So, in view of the said decision, in view of the directions passed by the Honorable Supreme Court in the case of Sukhendu Bachchaji, more particularly in para 76 thereof, read with the observations made in para 96 and 97, this court directs the petitioners herein to submit individual representations before the before the Secretary, Public Health Engineering Department within a period of 30 days from today. On receipt of such representation from the petitioners, the respondent, the Secretary, PHE Department, pura likh diya, shall consider the same strictly in accordance with the directions passed by the Honorable Supreme Court in para 76 of the decision in Sukhendu Bachchaji Supra, read with the observations made in para 96 and 97 thereof. Also, on such consideration being made and the matter being also placed before the Finance Department for its consideration, a speaking order releasing to the petitioners their due entitled benefits be passed within a period of 3 months, 4 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present writ petition stands disposed of.
Deeply obliged.
What are you? Oh dear. Amata. Where is that 2 pages?
Your Lordship, may kindly hear me for 5 minutes only.
I'll hear you for 10-15 minutes, no problem.
Your Lordship, I have committed a judgment, Amrit Yadav.
I may not give you relief, but I can't stop you from arguing, can I? Then? But sometimes to cut short, save time, judicial time,
I understand.
we have to interfere. Yes, Mr. Beria.
Your Lordship, para 31 of this said judgment. Amrit Yadav, please have something.
Amrit Yadav.
Yes.
Para 31. Take me to 3 facts.
Thanks, Your Lordship. This Deputy Commissioner Palumu has floated an advertisement for Class 4 employees. So, as per the terms and conditions of the advertisement, only written examination and cycle test was there. Subsequently, they introduced interview. So, some of the candidates who were not appointed approached the High Court. The High Court said since they introduced the interview and calculated marks by evaluating both written test and interview, that is why the High Court directed to prepare fresh list, which the state opposed. Thereafter, the state
Yes. Yes.
So this
para 31.
Yes. In our view, since the very selection and appointment of the appellant employee was a nullity in the eyes of law, the learned single judge committed no error in directing the respondent state to prepare a fresh panel of selected candidates without hearing the candidate who were likely to get affected. In this regard, we are benefited by the decision of this court in Union of India versus Raghupal Singh, wherein it was held that when the appointment of the candidate is a nullity in law, making them disentitled to hold the post, the principles of natural justice were not required to be complied with, particularly when the same would be nothing short of an exercise in futility. Then, Your Lordship, I'm turning to para 32.
Yes.
May I read your order? Hence, in view of the above principal and factual scenario in the case, it is clear that if the subject appointments were ab initio nullity in the eyes of law, it was not incumbent on the learned single judge to pass the order after hearing all the parties that were likely to be affected by such decision.
No issue. Got it. But this ratio has to be understood in the illegality that was noticed.
Your Lordship, now, whether they had the power to relax the norms, because the rule says no. Your Lordship may kindly turn to their additional affidavit. Page 117. That is the relevant rule, the Assam Rifles Havildar Clerk Recruitment Rules of 2013. Power to relax, where the central government is of the opinion that it is necessary or expedient so to do, it may by order of reasons to be recorded in writing, relax any of the provisions of the—
You are reading page
117 of their additional affidavit.
para? Oh, it's an annexure.
Annexure. Point number 8. This is the relevant rules, the Assam Rifles Havildar Clerk Recruitment Rules of 2013. The other rules which they have provided in the affidavit in opposition, that belongs to constable, not for Havildar Clerk. This is for Havildar Clerk.
No, where is the head and tail of this?
They have not, they have just provided.
No, you say that this is 2013. How
Yes.
do I get it that it is 2013?
Your Lordship may turn to page number 119, last FNA APERS 2013.
And the advertisement was of?
2017.
Where is the complete of this rules? Yes, Ms. Gan. You have brought this on record. Annexure B. Let us see the body. You have a point there. Let's see what happens. Tomorrow. Tomorrow is Tuesday. Okay, tomorrow. As prayed for by the Learner Council for the parties, registry to list this matter again tomorrow. The Learner Council for the parties to bring on record a copy of the recruitment rules that has been now a part of which has been now part of which is annexed to the additional affidavit filed by the respondents.
Much obliged.
So he is successful today.
In this case, also all the petitioner are grade 3 and grade 4 post, not the secretary of Gaon Panchayat Lodge.
Now, where is Mr. Dotto? Get hold of him. Call to all of ঠিক হইল। আগলে যাও। Mr. Das, what is the name of the school?
My lord, Simanto Siripani.
We can take it up for final disposal now. Srimanto
Srimanto Siripani, M. School Mali.
your appointment date?
My lord, it had been appointed on 3/2/1999.
As
As in, my lord, assistant teacher.
what subjects were you teaching?
My lord, I'm language, my lord.
And you are here now, the respondents are respondent number 7, 8, and 9,
Yes, ma'am.
right?
Yes, ma'am. Record person. Record. Huh? My lord, earlier occasion, my lord.
Just let me
Yes, ma'am.
get the fact. Respondent number 7 was appointed on
My lord.
Mr. Goswami, you are for respondent number 7. You are for 8 and 9. 7, who is there? Okay, he is not interested. He is not provincialized also.
He's provincialized, my lord.
After provincialization. No, did you get the benefit of provincialization?
He have not joined, my lord. He has made a communication to the headmaster. And that is, I have annexed in my writ petition on page 31, my lord. He's saying that he has been appointed as a TET master in somewhere else. Thereby, my lord, he has resigned.
Page.
Page 31, my lord. 31, one of my writ petition.
Respondent number 8, appointment.
My lord,
And as what teacher? And respondent number 9? Teaching subject? So, where is the provincialization orders or the list?
my lord, that is on
32.
yes, my lord.
Srimanto.
No, not on 32.
Who is Arun Kurmi?
Arun Ki means the headmaster, my lord.
No grievance against him.
No, no grievance against.
Who is Bisling Limbu?
Bislim Lingu is my lord, assistant teacher. He's junior to the petitioner.
Yes, science teacher.
Okay. Vistu Hatsa is respondent number? Nandeshwar Kurmi? And who is Naren Chandra Mahato?
Naren Chandra Mahato is respondent suppose who have my lord, left his service. My lord, he has been appointed as an assistant.
This is respondent number 7.
7, my lord.
5 teachers were appointed. No headmaster. No one was.
Including headmaster.
Arun Kurmi was as headmaster.
Headmaster.
And 4 assistant teachers.
Four assistants.
So, if we go by this, respondent number 7 was, what was he teaching?
My lord, as per their affidavit, he has been appointed as an assistant teacher.
For what subject?
My lord, my lord, record will reveal perhaps.
What subject? So now if you come, Bisling Limu, you have no grievance. He is social studies.
He's, my lord,
Social studies.
social studies.
Pishu Hatsa, you can have no grievance because he is respond number 8. He is a science teacher.
Science teacher.
So you can have got no grievance
My
against him.
lord, only my that submit, my lord, regarding that aspect, my lord, herein the considering the teacher people ratio, my lord, his name was not inserted, not available in the 9-10 to my lord, 9 and 10 my lord, dice data. So as per the my lord,
Because he was appointed in on 27/11/2009, so
Yes.
he naturally cannot be there.
my lord is correct, but he has not made any.
If I am correct, I am correct.
Well,
Let's
he has
proceed
not-
further.
But there is nothing in the record.
Now tell me, what about Nandeshwar Kurmi and Naren Chandra Mahato?
Nandeshwar Kurmi is the headmaster. He, my lord,
Nandeshwar Kurmi is Arun Kurmi is headmaster.
Yes, my lord. Nandeshwar Kurmi is my lord, Hindi teacher.
Hindi teacher.
Hindi
He was
teacher.
appointed on 5/2/99, that is after you.
Yes, madam.
So no language teacher. Now, what is respondent number 7? What was he teaching, Mr.?
He was teaching social science.
Basing limbo view social science.
First page.
Social science can.
These were the teachers recommended by the district scrutiny committee.
When was respondent number 7 appointed initially?
Respondent number 7 appointed on my lord 1/11/2008. Naren Chandra Mahato.
Okay. Yes. Why will he not be provincialized? Oh, forget your district scrutiny committee. That is error. That is why the person is before this court.
Is that non-recommendation there is
Null bit. Have you taken a plea in your writ petition that he is not serving in this school? Not there. Then you forget that. Now see, this respondent number 7, he was appointed as a social science teacher. Bilsing Limbu was also social science. So 2 social sciences were there. The apt would have been Arun Kurmi, headmaster. Then 3 mandatory subjects, Pitu Hatsa, then Bilsing Limbu, petitioner. The other post, there are 2 other posts. On seniority, whoever gets it, it will be Nandeshwar Kurmi as Hindi teacher if there is no teacher. Finished. What is more left? Yes, Mr. Goswami, what do you say? 8 is out of the way. 8, there can be no challenge. Science. Now 9, how does he come in?
My lord, we have explained, my lord, the seniority position is I am, my lord, senior to him.
You joined on 5/2. He joined on 3/2.
I joined on 3 to my lord.
Is it correct?
3/2/1999.
Where do I get the dates of joining, Mr. Das?
On my lord, page 28, my lord.
28.
28.
Ah.
20 petitioners name at my lord, serial number 1, 2, 3.
Serial number?
5, my lord. Bakeson back.
28.
Yes, my lord. Pakeson Bag on serial number. Date of joining, my lord. On the top, very small letters. Pakeson Bag petitioner. On right column 3/2/1999.
And respond number 9, Nondeswar Kurmi.
Nandeswar Kummi. My lord, Hindi,
He is also 3/2/1999.
yes, my lord. 3/2/1999.
But he is elder to you.
Yes, my lord. Considering the date of
Date of birth is. Age 28 may kindly be seen one.
But Hindi is not recognized as a language. It's a special subject.
special subject.
It's a special subject. Language would be as much as English, all those. Arabic, Hindi, these are all Sanskrit, these are all special subjects.
Special subject.
So the rule requires that three posts, one language, one science, one social. So why will he not come in as language? And you, considering your date of joining, as per seniority, whatever comes up, you will get it. Provided there is no one else. No, you can't be senior because you can't be treated as a language teacher. He is shown as English.
So Kurmi, my lord, the top page 28, man.
Hindi.
Wait, Hindi.
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 So language is, the first language I find is the petitioner. So Arun Kurmi is headmaster.
Arun Kummi is headmaster.
So we'll direct the respondents to now carry out a fresh exercise here. Read the post of respondent number 7 to be vacant because that was never utilized. That post created.
He can be accommodated, my lord.
But how, we don't know if something happens, because if we say seniority, some other teacher may also come up. I don't think so there are anybody. There is 195. Lakshmi Brahma. 1995. Oh no, that is in a different school. Sorry.
No, that is in a different.
So nobody is affected.
Yes.
Heard Mr. B.K. Das, Learned Counsel for the petitioner. Also heard Mr.
Only one thing, right? The interim order, our salary was stopped from June 2020.
Oh, we will get it now. You will get it now. Also heard Mr. P. Sharma, Learned Standing Counsel, Secondary Education Department.
Elementary.
Elementary Education Department. Mr. Your name? P. Khatoniya appears for respondent number 7, while Mr. B.D. Goswami, B.D. Goswami, Learned Counsel, appears for respondent number 8 and 9. The petitioner in the present writ petition has presented a challenge to the provincialization as effected in respect of the respondent number 7, 8, and 9 in Simanto Horupani Emi School. He has made a further prayer for a direction upon the respondent authorities to place his case before the jurisdictional district level committee for consideration of his case for provincialization of his services. Also, as projected in the writ petition, the petitioner was initially appointed by the managing committee of Simanto Horupani Emi School, bracket hereinafter referred to as the school, bracket over, on 5/2/1999. Also, the petitioner projects that he has been thereafter continuing with his services in the said school and was teaching the students primarily the subject English, the language subject English. Also, and his name was name figures in the DICE data from the year 2009-10 for the year 2009-10. Also, with the enactment of the 2017 Act, the case of the petitioner school was taken up for consideration for provincialization of the services of the employees working in the said school. Also, thereafter, the respondent authorities on carrying out the process of verification in terms of the provisions of the said Act of 2017 proceeded to provincialize services of 5 teachers working in the said school. Also, amongst the 5 teachers so provincialized, one of the teachers, that is Orun Urmi, came to be provincialized as the headmaster of the said school. Along with Orun Kurmi, 4 other teachers were so services of 4 other teachers were so provincialized, considering the number of students enrolled in the school at the relevant point of time. The petitioner who projects that he was working in this at school as an English teacher, not having found his name in the list of eligible teachers published for provincialization of their services, has instituted the present writ petition. Mr. B.K. Das, Learned Counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the respondent number 7, Nore Chandra Mahato, whose case was shortlisted for provincialization of his services, had left the school prior to the benefit of the provincialization being extended in his case. Mr. Das further submits that the respondent number 8 services, respondent number 8, who was a subsequent appointee, submits that the case of the respondent number 8 was found eligible by the respondent authorities for provincialization of his services, although he was junior to the petitioner with the date of joining, by reckoning the date of his joining in the school. With regard to respondent number 9, Mr. Das submits that respondent number 9 was appointed in the school as a Hindi teacher, and accordingly he cannot be construed to be a language teacher, and therefore his services could not have been regularized without first provincializing the services of the petitioner herein. Accordingly, Mr. Das submits that in any view of the matter, the petitioner is entitled to have his services provincialized either against the post lying vacant on respondent number 7 not joining his services in pursuance to the provincialization effected in his case, and or in place of the respondent number 9, that is the Hindi teacher. Also, Mr. Khatonia, Learned Counsel for the respondent number 7, has submitted that although the respondent number 7 was found eligible for being provincialized in his services, and orders in this connection were issued, the said orders were never implemented in his case, inasmuch as he had already left the services of the school on being appointed as a TET qualified teacher by the state government. Accordingly, he submits that the respondent number 7 would have got no further say in the matter. Mr. B.D. Goswami, Learned Counsel for the respondent number 8 and 9 at the outset has submitted that the challenge presented to the provincialization of the services of respondent number 8 would not be maintainable inasmuch as in a ME school, it is mandatorily required that a teacher who is teaching the subject of science and mathematics is mandatorily required to be provincialized in terms of the provisions of section 3 bracketed Roman 11 of the Act of 2017. Accordingly, he submits that the challenge to the provincialization of the services of the respondent number 8 by the petitioner must fail. With regard to the challenge presented by the petitioner to the provincialization of the services of respondent number 9, it is submitted that the respondent number 9 is the Hindi teacher and the same, and the said subject being a mandatory subject in a ME school, the respondent authorities had not committed any error in provincializing the services of the respondent number 9 by treating him to be a language teacher, right? By treating him to be a language teacher. Mr. Goswami, by referring to the particulars of the teacher as available on record, more particularly in Annexure 4 to the writ petition, has submitted that the petitioner and the respondent number 9 is found to have joined their respective services in the school on the same date. However, the respondent number 9, on account of his age, is senior is elder on account of being elder by way of date of birth to the by way of age to the petitioner, the respondent number 9 for all intent and purpose is to be deemed to be senior to the petitioner, and accordingly, in that view of the matter also, there is no error committed by the respondent authorities in provincializing the services of the respondent number 9. I've heard the learned counsel for the parties and also perused the materials available on record. So, at the outset, this court would examine the effect of the provincialization of the services of the respondent number 7 not being given effect to. It is a settled position that on the services of the employees in a venture educational institution, being provincialized under the provisions of the Act of 2017, the posts so created either would be personal to them, that is to say that the said post would cease to operate any further on the post being vacated by the incumbent whose services were so provincialized against it, or the post would continue to be in operation, and on a vacancy arising therein on account of any factor, the same would have to be now filled up by applying the provisions of the Act of the Assam Secondary Education Provincialized Schools Rules 2018. Having noticed the said position as obtaining in the matter, this court would continue with its examination of said issue. Also, the learned counsel for the respondent has fairly submitted that the services of the respondent number 7, although being provincialized, such provincialization of his services was never implemented. That is to say that the post so created for the purpose of provincialization of the services of the respondent number 7 was never utilized, and the same continued to remain vacant. The post not having been filled up and the petitioner not respond number 7 not having joined against the said post, comma, the post lying vacant now cannot be held to have lapsed on account of the petitioner vacating the same inasmuch as he had never joined against the said post, and or the said post being now required to be so filled up by applying the provisions of the rules of 2018. So accordingly, the said post, the post of assistant teacher as created for provincialization of the services of the respondent number 7 in the considered view of this court remains to be so utilized for provincialization of the services of an eligible employee in the school. Also, having drawn the said conclusion, this court proceeds to further hold that the challenge presented by the petitioner in the present writ petition of this court proceeds to notice the provisions of section 3 bracketed 11 of the Act of 2017. The provision of subsection 3 bracketed 11 being relevant is extracted herein below, page 111 A to A. Upor itu maidi bile 3 eligibility collage itu ase. Ini maidi bi. Ar pishot 11 to maribe. Dikene 11. Page 111 A to A. A perusal of the provisions of section 3 bracketed 11 of the Act of 2017 would go to reveal that in a venture upper primary school, comma, there shall be minimum 3 teachers or tutors, at least 1 teacher each for A, science and mathematics, semicolon, B, social studies, and C, languages. Further, the provisions of subsection, the provisions of 3 bracketed 8 mandates that in case of a venture ME school, there must be 1 science teacher or tutor to teach science and mathematics subjects. Having noticed the provisions of the rules of the Act of 2017 applicable to the present proceeding, this court, in view of the express provision, in view of the mandatory provisions of section 3(8) requiring requiring 1 teacher teachings, requiring provincialization of services of 1 teacher teaching science and mathematics, comma, the challenge presented in the present writ petition to the provincialization of the services of respondent number 8, who is found to be the only science teacher in the school, is held to be, by the petitioner, is held to be not maintainable. So, having drawn the said conclusion, this court would now examine the challenge presented by the petitioner to the provincialization of services of the respondent number 9. The learned counsel for the parties are at adium that the respondent number 9 in the said school was appointed as a Hindi teacher and he continued to teach the Hindi subject. In the scheme of the Act of 2017, comma, this court finds that the subject Hindi along with the subjects of Sanskrit, Arabic, music, Arabic, etc. have not been equated with the subject, with the language subject like English, Assamese, etc., Boro, etc. In terms of the provisions of section 311, there being a mandatory prescription to appoint, along with a science and mathematics teacher, social studies teacher, a teacher to teach the language subject, and it being found that the petitioner herein was teaching the language English in the said school, comma, in the considered view of this court, the petitioner, it was the services of the petitioner along with that of Whistling Limbu bracket social studies teacher, comma, Bishu Hazza science teacher, comma, whose services were required to be so provincialized. However, it is seen that the respondent authorities, without assigning any reason, has proceeded to equate the subject Hindi with that of the accepted language subjects and proceeded to provincialize the services of the respondent number 9. Accordingly, this court is of the considered view that the provincialization of the services of the respondent number 8 prior to that of the petitioner hearing was not maintainable. Is not maintainable. Also, having drawn the said conclusions, and this court having also concluded that there was a vacant post of that there was a vacancy available on account of the provincialization benefits not being implemented in respect of the respondent number 7, Naren Chandra Mahato, comma, this court is of the considered view that the interference with the provincialization of the services of the respondent number 9 at this stage would not be called for. So, however, this court, however, considering the fact that there is no recommendation made in respect of the petitioner by the jurisdictional district scrutiny committee, this court is of the considered view that the matter would now be required to be placed before the district scrutiny committee to verify the service particulars of the petitioner, and in the event he is found to comply with the requirements as set out in the Act of 2017, to recommend his name against the post lying vacant on account of the respondent number 7 not joining against the same, and or the provincialization benefits in his respect not being implemented. Provincialization order in his respect not being implemented. In the event the scrutiny committee, district scrutiny committee is of the view that the post held by the respondent number 7 would not come within the, would not further be available for consideration of the case of the petitioner hearing, the district scrutiny committee shall consider the case of the petitioner and the respondent number 9 in terms of the directions passed here, in terms of the conclusions reached by this court herein above, and thereafter recommend the candidate so found suitable for provincialization of their services. Also, the petitioner in the event is found eligible for being provincialized in his services, his such services shall be provincialized after completion of the process involved with retrospective effect, that is with effect from the date the services of the respondent number 8 and other teachers in the said school was so provincialized. So accordingly, the director, secondary education, accordingly, the petitioner is directed to submit a representation before the director, elementary education, along with a certified copy of this order, staking a claim for being provincialized in his services within a period of 15 days from today. On receipt of such representation from the petitioner, comma, the director of elementary education Assam shall take all requisite steps to place the case of the petitioner before the jurisdictional district scrutiny committee. Also, the district scrutiny committee shall thereafter verify the service particulars of the petitioner strictly in accordance with the conclusions drawn by this court herein above in the present order. On drawing of such conclusion, the district scrutiny committee shall place its recommendations before the Director, Elementary Education for further processing of the same in terms of the provisions of the Act of 2017. Also, the said the exercise now required to be initiated for compliance of the directions passed by this court herein above shall be initiated by the Director, Elementary Education and concluded within a period of how many days? 3 months from the date of receipt of a certified, 4 months, 4 months from the date of receipt of a certified copy of this order, along with the representation from the petitioner by the Director of Elementary Education Assam. So, with the above observations and directions, the present, huh? Oh, so, the in view of the above conclusions, direction to report. It is directed that the salaries of the respondent number 8 shall be released. I'm coming to 9. Respondent number 8 shall be released to him with retrospective effect within a period of 1 month from the date of receipt of the certified copy. Also, with regard to the prayer made for release of the salaries of the respondent number 9, it is directed that the same shall be so permissible only after only after the exercise directed to be carried out in the matter by the Director of Elementary Education is so concluded and orders passed thereon. In the event the petitioner respondent number 9 is found to be eligible to be continued in his provincialized service, his salaries also shall be released with retrospective effect, that is, with effect from the date the others in the said school were so release their salaries on being provincialized in their services.
They were getting salaries. Salaries were stopped subsequent to the time order passed.
Retrospective effect, that is, with effect from the date the salaries were so stopped in pursuance to the interim directions passed by this court in the present petition wide order dated 25/5/2022. To the said extent, the interim directions passed by this court wide order dated 25/5/2022 stands vacated. With the above observations and directions, the petition stands disposed.
Obliged. My lord, one thing, my lord, the date of joining of the petitioner is perhaps written as 5/3. It is to be 3/3, my lord.
3/3. 3/2.
3/2, my lord. 3/2. My lord.
No.
My lord, the date of my lord.
No. Resolution is dated 3/2. You joined on 5/2. Appointment is 5/2.
The date of joining is my lord 5/2.
5/2. Hey, to appointment 3/2, and he joined his services on 5/2.
9 is also same.
5/2, 1999.
Date of joining.
Date of joining. And join appointment. No. He appointed on 5/2/1999 and joined on the same day. Bas.
What, my lord, respondent number 9 in petition?
We'll see.
Fine.
Respondent number 9 appointed on 5/2/99, joined on the same day.
Obliged.
Here, Lordship, it's similar to Lordship, Lordship, here similar matters are fixed on 16th.
On the prayer of the Mr. A. Cholia, Learned Standing Counsel, Finance Department, registry to list this matter again on 16 July, 16/7/2026. Ms. M.D. Bora, Learned Standing Counsel, Transport Department is present. But there is a specific order with regard to Transport Department in Sukendu Butsaji. Few days.
Yes, sir.
Let them have that. We'll see.
Fine. All the petitioners are not entitled, my lord. All the petitioners are not entitled, my lord.
You make a list of the petitioners who are entitled.
I have made that. It 17.
And Mr. Cholia,
16 there.
you or Mr. Gogoi or Mr. whoever appears on the next day, address this court. Now Upendas is gone.
Lordship.
So with that, that minimum scale of pay is gone. So are you taking a decision that whoever are not entitled, you will be entitled, you'll be extending to them? Or we will have to reiterate Jagjit Singh?
Is being taken jointly with.
Okay,
keeping all.
okay, okay, okay. Yeah.
In 14, my lord, on the last occasion, the state council took time to file affidavit, my lord. They have not filed the affidavit till today, my lord. In some instruction, they received.
Forget the instruction, you say
Malad,
what you
Malad, asked her to produce Malad, give a copy of the instruction to me, Malad, so that I can go through it, Malad. But she insisted on filing the affidavit.
Affidavit is filed.
No, my lord. Thereafter, no.
Who?
M. Bhattacharjee.
No, forget the affidavit. Now, Mr. Rukya, forget everything. The adoption has to be there. Right? Now, the adoption is further channelized by saying adoption, memorandum, and then you proceed. Just show me these two things.
Adoption is there, Malad. Malad, the memorandum is not there. Malad.
And even the adoption is also very, very vague. Page 33.
That is.
So what more is required? You are not a C1, you are C2 or something.
It is.
C2. So that
C2.
C2. So you're not covered by that decision.
With also.
And this decision is of 4/8/2016 of the managing committee or the board of directors. And it was made effective for existing working employees. So on that day, the existing employee was only Albanson Sushen, that is respondent petitioner number 3.
1.
And Ikaram Sharma, that is respondent number 5.
Petition number 5.
Right?
Petition number 3 and 5, my lord.
3 and 5. So we close this repetition by holding that in the event the benefits of the 5th, 6th secrecy is applied in the organization with retrospective effect, that is with effect from the date when you were in service, the benefit thereof should be given to respondents number 1, 2, and 4.
No, my lord. If 6 CPCs, my lord, my lord, adopt the CPC, my lord, all the petitioners will be entitled. Because
So,
during that period,
but that adoption has to be not in terms of 6 CPC. Adoption has to be done in their own terms. And they have said that this is applicable only to existing workers, not to the other workers. We can't saddle them with that because they are otherwise also not functioning. There was one decision, A.K. Bindal.
A.K. Bindal is a different case, my lord. A.K. Bindal, in that case, my lord, the organization did not take any decision. And that is why, my lord, the apex court hold that, my lord, the organization has the liberty to take decision of their own.
There was one case wherein I was appearing for state employees,
My lord.
that SLPE scheme. I had a stay order in respect of 201 employees. I was very happy. Matter came up before Justice Gugoi. On the first date, he was okay. Extended the interim order, directed them to process and all. Second day, when the matter came up before him, he asked me only one question. Mr. Nair, have you seen a PDS shop near you? PDS shop. Fair price shop. I said, yes, my lord. Out of that PDS shop, how many people survive? I said, what is there near me? At least 3 brothers, family, 10, 15 people survive. Then he asked me, have you been to Borpeta? I said, yes. Have you seen the bus operators there? 1 or 2 bus, how many members of the family survive? I said, many. Then, why an organization like State Fed has come to this position? You are also responsible. He vacated the interim order. And rightly so. Rightly so. Because this is a systematic failure and the employees are also responsible. No sympathy. So we'll close it and we will direct that in the event the board, after reviving itself, takes a decision that the benefits would be taken with retrospective effect from the date 6 CPC, ROP rules 2010 came into being, all the petitioners shall be considered for the said benefit. I just want to forgot one, not just it came, AK Bindal. Just want to see what it is. Possible? You have that? Observation was. Mr. Swekya, let me just go through this AK Bindal. I'll pass the order in the second half. Second half. God bless you. Regularization not permissible. But what about the minimum skill?
Yeah, that's similar, Lordship.
16th, as prayed for by Mr. A. Cholia, Learned Standing Counsel, Finance Department, registry to list this matter again on 16/7/2026. Because Upandas has now been set aside. So there has to be, there is a vacuum now. Either we fill it up, we direct for its filling up, or they fill it up on. We'll give them a chance. Let's see.
Will monitor our filling.
We have enough other matters to do. We will direct. Yes, madam. What has happened? Cleared. Oh, you tell me whether cleared. No, why? Why? Madam, wait for 2 weeks. Ms. D. Bora, Learned Standing Counsel, Health and Family Welfare Department, on instructions received, has submitted that the leave encashment benefits sanctioned to the petitioner earlier had lapsed on account of non-drawal of the same. She submits that the processing with regard to the matter not being completed, the amount involved could not be drawn. However, she submits that that the matter has already been processed for re-sanction, and the same would, and the process involved would be completed within a period of 1 month, within a period of 1 month from today. So, in view of the above development taking place in the matter, this court directs the respondents to expeditiously process the matter and authorize to the petitioner the due leave encashment benefits on or before the next date of listing. The amount involved be credited in the account of the petitioner on or before the next date of listing. Registry to list this matter again on 14/7/2026. In the meantime, you will get it. It's re-sanctioned only. Mr. K. Medi, your K. Medi is present on behalf of the respondent number 4.
May it please your lordship.
You piecemeal basis, you do it. Last time I asked you, what are the documents you require? You gave me an undertaking that these are the documents required. Be directed. Now that order is now nearly
6
2
months.
months, nearly 1.5 months. And prior to that, it is now 3 months.
Secondary. Subsequently, now, second.
Now, what are the further documents you require?
Query by the secondary.
Oh, you are for the elementary. Why are you in the firing line? You go. Yes, Mr. Sharma, you are sitting calmly, huh? You are the main culprit.
My lord, here process going on, my lord, and the matter.
Process, you go on. We don't have time to deal with this matter daily. I want an answer today.
This is my instruction.
Or I am going to draw up quantum proceedings. Your inspector was here? Huh? The inspector gave an undertaking that everything is done, processed with the director. This was on 11/3/2026. Today,
Director. And accordingly, government asked for some documents and which has to be collected from the elementary education department. And accordingly, director secondary education.
when did you receive this letter from the director secondary education? It's nil here.
It is written 29/4/2026.
1 month after the order. And what are the documents you want? Copy of the order dated 23/3/2018. Where is this in the writ petition, Mr. Rana?
Page 46. Annexure 7 and Annexure 9 respectively, page 46 and 49.
This is with your government? Then why did the government ask this? Huh?
It is before the elementary education department, my lord.
Your Lordship, this is a wrong statement made on oath. The secondary education was made a party. I have annexed that order also. Your Lordship will kindly come to page 68.
Okay, Mr. Sinha, please have a seat.
But these documents are asked by the government from the director.
Now, there is a government for elementary. There is a different government for secondary. It's one only.
Now it is
So this page 46, if it is with the commissioner, second to commissioner and secretary elementary education department, that means it's in the Department of School Education now. Huh? They don't have a system of indexing files.
for that purpose, the two letter has been issued. 2026 is
Lekha. Heard Mr. R. Singha, Learned Counsel for the petitioner. Also heard Mr. U. Rama, Learned Standing Counsel, Secondary Education Department, and Mr. B. Talukdar, Learned Standing Counsel, Elementary Education Department. So, Mr. Sharma at the outset has submitted that the proposal for release of the arrears salaries of the petitioners was placed before the government in the Department of School Education. However, while processing the matter, the government in the Department of School Education had sought for further documents via a communication dated 27/4/2026. Accordingly, the said documents being in the possession of the Director of Elementary Education, a communication was issued by the Director of Secondary Education Assam for receipt for being furnished the said documents to the Director of Elementary Education Assam. Mr. Talukdar, B. Talukdar, Learned Standing Counsel, Elementary Education Department has submitted that all the required information has now been furnished to the Director of Secondary Education by the Director of Elementary Education by the communication dated 6/6/2026. Mr. Sharma submits that the said information having been now received, the same would be forwarded to the Department of School Education Assam within a period of 7 days from today. The Department of School Education Assam, the Secretary or Commissioner? Commissioner and Secretary to the Government of Assam, Department of School Education, is thereafter directed to process the matter and pass an order towards a release of the area salaries of the petitioners if they are found to be so entitled within a period of 1 month from the date of the receipt of the requisite documents in terms of the directions passed herein above from the Director of Secondary Education Assam. Registry to list this matter again on May 2026. On the next date of listing, the consequential orders passed by the government in the Department of School Education shall be placed before this court.
Your Lordship, now and then they'll come up with everything, it requires something. Whereas this document was very much within their domain. In spite of that, this lady,
Mr. Singha, you maintain your files very nicely. Unfortunately, that is not the thing there. You have small number of files. They have Much.
The issue is not
So
that.
some document from here, it might have gone there.
Let them ask
Give
everything in
long-
one go. Let
Let
them
us
ask
give
everything in
them
one
the-
go.
Oh, let us give them the longest rope possible. Then we will do.
Your
it.
lordship, two of the petitioners' money has been cleared long back. Why the others have not been cleared? If the documents are not there with them.
Okay, you want to argue?
If your lordship wants to pass, your lordship will pass this.
Or you want me to pass the order today itself? Okay, done.
Your lordship, this is a clear case of contempt. That's what I'm trying to point it out by the director of secondary education.
Okay,
They are trying to frustrate the office.
they are not sitting over the matter. They are processing the matter.
Your lordship
So
will
let
kindly
them,
say-
let them, let
Your
them
lordship,
do.
as an officer of the court, let me point out one thing. This letter which I have annexed today in the additional affidavit, this letter was issued on 29th. And they say the government has issued them the letter on 27th when the matter was listed. So they remain quiet for a long time and they pass the orders only when the matters are listed.
Okay, we understand that. We understand that. But Mr. Singha, we'll also have to consider if they are processing the matter, let us do it. If not, we are not remediless. You're not remediless, and we are also not powerless to compensate you by giving you interest.
If that be the case, then I will leave it to you.
So
Deeply
today,
appreciate.
the steps this court is taking is to see who should be saddled with that responsibility. Enough. Next date. I did not pass the order to pass final orders, did I, till today? Today I have passed that order. Let us see how they react. You want the money? At the rate it should have been given to you. Why get agitated?
I'm deeply.
Why get agitated at this?
The agitation is only as an officer of
Please,
the court.
no, it's not as an officer of the court. It is as a
No.
as an advocate of a officer of a court. You never get agitated.
Of course, but
We
what
can
is,
never
what
get
is, what is disturbing me is that we're trying to toy with the orders of the court
Oh,
every time.
we know how to take care of it.
That's it.
We know how to take care of it. Mr. Sharma, please proceed with the matter as at your convenience.
Deeply obliged, Your Lordship.
But tell your director that if it comes to that, we pass orders, we will direct the chief secretary to withhold her pay.
Need to file one now filed.
They have not filed affidavit.
Oh, forget their opinion. Tell me, what is your right?
The petitioner was engaged. No formal engagement letter was issued.
Then where is your right being accrued?
The certificate issued.
Certificate issued, what?
One thing.
This is government job. There is a set procedure.
Till date,
Where is an agreement that is there between you and between your elder brother and the government that if you take my house on rent, you will have to appoint my brother?
That means whatever.
You have participated in the selection process. There was a selection process. First, you participated. Second one, you could not.
2014, an advertisement was issued.
And now they have appointed somebody against that post.
That was in the year 2020.
Be that as it may, there is somebody who has been appointed. Now, how can you be recognized? Yes, Ms. Goswami.
May it please your lordship.
Yes, yes. Show me the right accruing to you in the matter.
Yes, your lordship. Right accruing to me is Supreme Court judgments, your lordship.
Okay. What
Nothing,
is that?
there is, your lordship is absolutely correct. There is no appointment order.
There is nothing.
There is no appointment order.
You volunteered to serve.
Yes, your lordship. Volunteering is what Jagjeet Singh says. That's not voluntary. It's you retained and availed my service for 20 years.
Yes, that was there. It's
Lordship,
already
may I
filled
just,
up.
yes, your lordship, but I applied in time. Lordship, may I just tell you briefly? The office was set up. It belonged to my brother. They wanted a class 4 peon. So they engaged me. There's no appointment order, but we have an annex certificate from 2009 to 2026 where the director, not director,
Was there a
the
contract
project
entered into?
No, there's no
This-
contract. There's no contract. This is typical of how ad hoc
No,
appointees
this is
are.
not typical of ad hoc.
Lordship, the last few cases, Dharam Singh is a case where there is no
Is
contract.
a case wherein there is a proper engagement, albeit on ad hoc basis.
Yes, your lordship.
Here there is nothing.
Lordship, then the question arises is, can you engage somebody
Yeah,
and
go and file civil suits, claim your
then it
damages.
violates Article 23, Article
It does not.
21?
if you can be engaged and regularized like this, it violates Article 14 of many others.
But Lordship, you have engaged. May I, Lordship?
There is
quickly-
no engagement, madam.
Lordship, may look at page 47 onwards.
It says
Page
that he is
47.
working voluntarily. And these certificates, we are not going to give it any credence.
And Lordship, they are not disputing that he is engaged and he is working in a grade 4 service. I applied. When in 2014, that didn't go through. Then it again, my applications were forwarded to and fro. Lordship,
The
can you-
subsequent advertisement
I
that you
could not
made,
apply because I was overage.
you have not even made an application for condonation of your overage.
No, that because, Lordship, we have not.
No,
That is,
you could have made an, it's not that you had reached the age of 45.
Lordship, in
You
the
had just crossed 38.
we had Lordship in the meanwhile asked a representation for regularization.
That is no representation. There was a regular selection done. Persons have been appointed. The posts have been filled up.
Lordship,
And that is the end of the matter.
may I rely on the cases? Lordship may take note. And
Those
Okay,
cases we reject. I'll follow my division bench judgment. Dharam Singh and all. There is
Yes.
nothing here.
Lordship, may I just cite one paragraph of Jagdish Singh? And Lordship may hold it to be not applicable.
I'll do that. You tell me.
But let me just place for your Lordship here. Because it is very disconcerting that a state agency avails services for 20 years and then puts up their hands and says, sorry, it's involuntary. Yes, your Lordship. Jagjeet Singh is paragraph 58.
Show me one representation preferred by you wherein you have prayed for giving you salaries or wages.
Lordship, may I finish Jagjeet Singh and come back to it?
Fine.
Paragraph 53, no? Paragraph 58, your Lordship. May I read, your Lordship?
It's okay, I'm reading. Yes.
Lordship, I rely on the last. Any act of paying less wages as compared to others similarly
it.
situated
That's it.
constitute an act of
That is what I said.
emerging from a diminutory position.
Madam Goswami, that is what I said at the first go.
Yes.
It is a case wherein wages were paid, but found to be below the minimum sustenance wage. But show me one application of yours here.
Yes, your Lordship.
Wherein you have prayed.
Lordship, may I start from 2014 onwards? The first advertisement came in 2014.
No, I want to
Lordship, page
see.
24. Page 24
I want to
onwards.
see one application
Your
of
Lordship.
yours praying for giving you salaries.
Lordship, this is an application for page 24. I applied for regular appointment.
Oh, forget regular appointment. After 98, now that is not possible.
Yes.
When
yes,
was
your
your
Lordship.
first engagement?
2007.
2007. So
Yes.
now Sukendu Bachchaji has come. Anything after 1493, gone. In the context of Assam. Sukendu Bachchaji
Yes,
is the
yes,
latest decision.
Justice Mehta's judgment. Yes, but it says that you go ahead and regularize. And
No, it
whoever
says
similarly-
all persons, last paragraph, appointed prior to 1493.
In that context of the circular.
No, it is in the context of Upendas.
That's right, your Lordship. That's
So
right.
Upendas had put a bar
That's
on
right.
provincialization.
Yes.
Now, Supreme Court has said that, sorry, you regularize, you will have to regularize, but this directions will be limited only to 1493.
In the context of that case, your Lordship. Otherwise, then what is the meaning of-
This is the most apt case now.
Yes, your Lordship.
That is
page
applicable
26.
to the situation here.
Page 26.
Yes.
Page 26 is my
Regularize your services.
services.
Where is your application seeking wages?
Lordship, then your Lordship may turn to page 28.
Yes.
I'm saying till date without this thing. And
But
therefore
there is
this-
nothing here again. No wages claim
Lordship,
for.
He's a clerk, he's working without. He's saying, please regularize means please pay me. And he's
That is
saying,
why
page
they use
28.
the term voluntary. You never claim for wages. If you have been working, why have you not claimed for wages?
Please, 28, yes, page 28, your lordship.
Wages is there?
Yes, we've complained that without any wages.
That is different. You
Till
have.
date, lordship, that's on semantics then, your lordship.
Oh, we have been lying so and so, being and carrying out so and so, with just a hope of regularizing my services. Where is that prayer of yours?
And
That
then
why
if
you
we want
taking
to
my
forward it.
services?
No, lordship, we have not said categorically, please pay me. We have complained we've not been paid and regularize.
Okay, anything more, Ms. Goswami?
Nothing, lordship. I
Yes.
rely on Dharam Singh.
Yes.
The affidavit filed by respondent number 4 is that is spring services voluntary. In that paragraph number 4, second paragraph, for engagement letter was issued and post asset was already filled up with.
No application for condonation of overage also made by. But Ms. G. Goswami, counsel, except assisted by Mr.
Chaudhary.
Chaudhary. H.I. Chaudhary, learned counsel for the petition. Also heard Mr. D. Bora, learned counsel for the respondents. Hearing concluded, registry to list this matter again on 16/6/2026 for delivery.
Oblige, your lordship.
Just give me a list of the decisions Miss Senior wants to rely upon.
Oblige, your lordship.
Yes.
For that, what would have been, because he has actually counted the year. If the records reveal that if he has.
Mr. Bora, what is here? Nothing. Huh? It was an allegation, POSCO leveled allegations. Huh? Now come to your inquiry report. If you people conduct such perfunctory inquiries and you expect this court to uphold that, it's too much. Come to page 45, discussion on evidence, and tell me what is the material there.
Worship.
Oh.
Read.
Examination.
So and so. Read further.
Sorry, 521. So that.
Now very carefully read from that and comes to light that on. That is the conclusion. On. Delinquent. Barber so-and-so was arrested and forwarded to judicial custody in connection with so-and-so. After 68 days, he has been released on bail by the court. The case is charge-sheeted and now pending trial. Opinion. Considering the aspects and the evidence, it comes to light. So, only because he was involved in a criminal proceeding, forwarded to jail, charge-sheeted, he has been done. Now that criminal case has entered in his acquittal. Everything goes. And what is the penalty? With this very serious charge too, we are interfering. Anything you have to, your Mr. Ghosh seems to be very sad. Huh? You don't want us to interfere? I'll interfere. Okay. Yeah. I'll pass the orders today. Delivery of orders.
Right.
Third, the learned counsel for the parties. After the last date of hearing, the petitioner has filed, and it is seen that the petitioner has filed an additional written argument, and the respondents have also brought on record their written argument. This court, these written arguments were unfortunately not there, so I could not go through it yesterday. They said written arguments would have to be perused by this court. Accordingly, the delivery of order is deferred. Registry is directed to list this matter again on. Stay here, Pari. Immediately. 13. 14/7/2026 for delivery. Yeah.
Obliged, your lordship.
Heard Mr. D.M.H.R. Khan, learned counsel for the petition. Also heard Mr. D.K. Roy, learned standing counsel. You tell that name, I forget. That doesn't come to my mind. For me, it's still Assam Higher Secondary Education Council. Assam State School Education Board. Board, it's not board, na? Board. Board. Aisha. The petitioner in the present petition has raised a grievance with regard to the non-consideration of his application submitted before the authorities of the Assam State so-and-so for correction of his date of birth as recorded in his HSLC examination records of 1984. As projected in the writ petition, the petitioner herein had appeared for his HSLC examinations in the year 1984 and had cleared the same. So, the respondent authorities of the then board of the authorities of the then Board of Secondary Education Assam had issued to the petitioner a certificate in this connection. In the said certificate, the date of birth of the petitioner was recorded as 1/10/1966. The petitioner is thereafter found to have been appointed as an assistant teacher in Palihamari Pam MV School, while order dated 31/1996. After the petitioner was so appointed, the petitioner had submitted an application before the secretary of the then Board of Secondary Education Assam for correction of his date of birth as recorded in his HSLC records as 1/10/1968 in place of 1/10/1966. Apostrophe. So, the petitioner thereafter is also found to have obtained a birth certificate after registering his birth with the authorities of the Department of Health Service, Directorate of Health Services on 2/11/97. So, the petitioner's date of birth not being corrected even after this birth certificate was placed before the respondents, the petitioner has instituted the present petition. The learned counsel for the petitioner next has, by reiterating the said facts, submitted that the birth certificate of the petitioner would reveal that the actual date of birth of the petitioner is 1/4/1968 and not 1/10/1966 as recorded in his HSLC certificate. The learned counsel for the petitioner has also referred to the note made by the principal of the school from wherein the petitioner had appeared for his HSLC examinations, as well as a communication dated 33/98 issued by the Assistant Inspector of Schools, Morigaon, District Circle, Morigaon, wherein the fact that the date of birth of the petitioner was 1/4/1968 was reiterated. The learned counsel for the petitioner accordingly submits that the petitioner is entitled to have his actual date of birth recorded in his HSLC records, and accordingly an appropriate direction be issued to the authorities of the Assam State to ASSEB to correct his HSLC records and record therein his the correct date of birth of the petitioner. Next, for contra, Mr. D.K. Roy, learned counsel appearing, learned standing counsel, ASSB, has submitted that the date of birth of the petitioner is not recorded by the authorities of the was not recorded by the authorities of the then Board of Secondary Education, Assam, on their own motion, but they said date of birth is so recorded basing on the particulars set out in the, what do you call that, MRS? What is that full? Huh? That is given by the school. That is given by the school.
We have annexed that.
No, this is your recording. What that school sends that form, what is it called?
MRS.
MRS only. Is based on the MRS submitted, furnished by the school authorities with regard to the particulars of the students appearing from the said school. So, Mr. Roy, by referring to the MRS submitted by the school authorities in the matter, has submitted that by referring to the MRS submitted by the school authorities in the matter, has submitted that the date of birth of the petitioner therein was recorded as 1/10/66 by the school authorities. So, he submits that accordingly, basing on the said particulars furnished by the school authorities, the date of birth of the petitioner in the records of the Board of Secondary Education, the then Board of Secondary Education, was recorded as 1/10/1966. Accordingly, he submits. Mr. Roy further submits that the correction, if any, with regard to any particulars mentioned in the HSLC certificates is required to be so made by submitting an application within 3 years from the date of issuance of such certificate. It is found, Mr. Roy submits that the petitioner had cleared his HSLC examination in the year 1984. However, the first application for correction of his date of birth was so preferred only on 8/2/1997. Accordingly, Mr. Roy submits that both on the count that there was no mistake occasioning on the part of the Board of Secondary authorities of the then Board of Secondary Education in recording the date of birth of the petitioner, and the delay occasioning on the part of the petitioner in making an application for the correction so required, the claim made by the petitioner in the present petition would not mandate acceptance by this court. I've heard the learned counsel for the parties and perused the registration of death and birth. Peruse the materials coming on record. So, the petitioner herein admittedly had passed his HSLC examination in the year 1984 with roll R-35, number 89. So, the authorities of the then Board of Secondary Education, Assam, had in this connection issued to the petitioner his high school leaving certificate examination 1984 certificate, and therein the date of birth of the petitioner was recorded as 1/10/66. The petitioner is found to have thereafter pursued his further studies, and on acquiring the requisite eligibility is further found to have been appointed as an assistant teacher in Falimari Palm MV School by an order dated 31/96 issued by the District Elementary Education Officer, Morrigaon, Assam. Morrigaon. Till the petitioner was recruited as an assistant teacher in the said school wide issuance of the order dated 31/20/1996. The petitioner is found to have not raised any objection with regard to the recording of his date of birth in his HSLC certificate. After having been recruited as an assistant teacher by the order dated 31/96, after around lapse of 1 year, after a lapse of 1 year from the date of his recruitment as an assistant teacher, by the order dated 31/96, the petitioner is found to have submitted an application to the Secretary, Board of Secondary Education, Assam, on 8/2/97. On the body of the said application, the principal of Buragaon Horisaran Sarkari HS School is found to have made an endorsement to the effect that the date of birth of the petitioner, as per school records, was 1/4/1968 and not 1/10/1966 as recorded in his HSLC certificate. The petitioner thereafter is found to have obtained a birth certificate from the Directorate of Health Services. A perusal of the said certificate would go to reveal that the application for the same was so registered on 2/11/1997, and the certificate was issued to the petitioner on 13/2/1998. While the said certificate has been brought on record, the petitioner in the writ petition has not made any, has not brought on record any materials to demonstrate that the registration of his birth, that the delayed registration of his birth was so effected by strictly complying with the provisions of the Registration of Births and Death Act 1969, and the same was so done after the approval of the competent authority in this of the designated authority for grant of such approval for delayed registration of birth and death. Accordingly, in the considered view of this court, the said birth certificate would be of no consequence and would not mandate to be so reckoned for the purpose of considering the claim made by the petitioner in the present writ petition. So, this court, from the affidavit filed by the authorities of the Assam so and so. This is by the Board of Secondary Education is continuing, no?
No, my lord.
Then why a Secretary Board of Education you have written here?
At that time,
It was there, okay. By the then Board of Secondary Education, Assam, this court finds that the date of birth of the petitioner in his HSLC records was recorded basing on the particulars furnished of the students appearing in the HSLC examination 1984 by from Buragaon Horicharan Sarkar High Secondary School, by the authorities of the said school. A perusal of the particulars so furnished in respect of the petitioner reveals that the date of birth of the petitioner was recorded as 1/10/1966. The authorities of the then Board of Secondary Education had only recorded the date of birth of the petitioner as was furnished by the school authorities. Also, further, as per the regulations holding the field, a correction with regard to any fact noticed recorded in a HSLC certificate is permitted to be corrected if such application is made within 3 years from the date of the examination concerned, along with payment of necessary fee. So, however, in the present case, it is found that the petitioner had appeared in his HSLC examinations in the year 1984, and after 13 years of having so appeared in the said examination, an application for correction of his date of birth as recorded in his HSLC certificate came to be made on 8/2/1997. The delay occasioning on the part of the petitioner in approaching the respondent number 2 for correction of his date of birth is not explained in the writ petition. Also, accordingly, this court is of the considered view that the application, that the delayed submission, that the application as submitted by the petitioner for correction of his date of birth was with a view to take a chance of an extended service period after he was appointed as an assistant teacher in Falia Mari Palm MV School. Also, accordingly, the claim made by the petitioner in the present writ petition is not found to be acceptable. Also, in view of the above discussion, this court is of the considered view that the prayer made by the petitioner in the present writ petition would not mandate acceptance, and accordingly, the same stands rejected. The writ petition next. Writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, there would be no others. Mr. Bhattakur, your one. We are interfering with the suspension order, but we'll give you liberty to challenge your, because that has come by way of an additional effort. We'll give you liberty. Have you retired? You have not retired?
No, not yet.
You will be reinstated forthwith.
Lords.
I'm passing the order in the two. But that show cause notice,
Lords.
because it came subsequent.
Lords.
So you have not amended the writ petition.
Lords.
So you file I'll leave it up to you.
Lords.
File appropriate application for that.
Lords.
Next, automotive to deliver.
Deeply obliged.
Taking it inside, it gets accumulated. Now this is the system. This is better.
Next.
Okay, we'll pass it. Don't worry.
Item 57. Respondent number on 8th of March. My learned friend, the petition has to be brought and report the death certificate.
No, substitution has to be done. That is the second wife.
Second wife.
Respondent number 7 is the second wife.
Yes.
Mr. R. Islam, Learned Counsel for the respondent number 7 submits that the respondent number 7 during the pendency of the present proceeding had passed on
8th of March.
28/3/2026. Mr. Your name?
J. Monto.
Mr. J. Monto, Learned Counsel for the petitioner submits that he would file an appropriate application for substitution of the respondent number 7 within a period of 2 weeks. 2 weeks from today. Prayer accepted, registry to list this matter again after 2 weeks on a date to be fixed.
Obliged.
और बोर्ड है ना हमारा free as an issue. Give me 2 minutes. She has taken much today. Have somebody else. তোৰ এইটো হৈ গৈছে নে চোন? তইতো লোৱা নাই ডাঙৰ আজি। But Mr. S. Bothakur, Learned Senior Counsel, assisted by Mr.
P. Khatonier.
Pete Khatonier, Learned Counsel for the petitioner. Also heard Ms. M. Bhattacharjee, a learned additional senior government advocate, appearing for all the respondents. He is appearing for all the respondents.
Proceed.
Also, the petitioner in the present petition has presented a challenge to his prolonged suspension, occasioning after he was placed under suspension while issuance of an order dated 19/2/2025. The petitioner has also assailed a show cause notice dated 26/12/2024, instituting against him a departmental proceeding. Also, as projected in the writ petition, the petitioner, while working as a superintendent in the Directorate of Tea Tribes and Adivasi Welfare, Assam, a purchase of 2702 numbers of Spatsmoon came to be made in the directorate. So, out of the purchased smartphones, 2570 numbers were distributed to line sardars of various tea gardens during the year 2021, and the remaining 132 numbers were kept in the directorate building for distribution in the contractual staff of the program management unit of the directorate. Also, it is further projected that out of the 132 numbers of smartphones, 35 numbers were kept in the almirah of the director, and the rest 97 were kept on the third floor, that is third floor of the music building. The third floor, that is music building of the office. Also, audit team from the Office of the Principal Accountant General, Assam, had carried out an audit in the office in the directorate with effect from 24/8/2024 to 10/10/2024. During the said audit, the audit team did not physically find the 97 numbers of smartphones kept in the third floor, that is museum building. And also, the same were not found to be available in other places of the directorate. Also, with regard to the said loss, explanation calls, communications seeking explanation from the petitioner came to be so issued. And as much as it was projected that the smartphones, 97 smartphones were kept under his custody. Also, subsequently, the director, Tea Tribes and Adivasi Welfare, Assam, directed the joint director of the directorate to carry out an inquiry with regard to the loss of 97 smartphones from the premises of the directorate. Also, on conclusion of the said inquiry, a report was submitted, and therein it was projected that the petitioner being the custodian of the smartphones, missing smartphones, he is solely responsible for the missing of the same. So accordingly, on 21/12/2024, an FIR was lodged before the Paltam Bazar police station with regard to the loss of the 97 numbers of smartphones from the premises of the directorate. The said case was registered was Paltam Bazar PS case number 465/2024 under section 305 bracket of Vitorot small a DNS, 2023. So, thereafter, a show cause notice. Thereafter, it is projected in the writ petition that a show cause notice dated 26/12/2024 came to be issued to the petitioner, seeking a clarification from him with regard to the loss of the said mobile phones. Petitioner is found to have submitted his clarifications in the matter. Also, in the meanwhile, the petitioner was also enlarged on bail by this court in connection with Paltam Bazar PS case number 465/2024. The petitioner was issued with a further show cause notice on 7/1/2025, seeking a written explanation from the petitioner for his absence from office on 3rd, 4th, 6th and 7th January 2025 without prior permission or intimation. Petitioner replied to the said. Petitioner submitted his clarification in the matter and had set out the reasons of his why he had to remain absent from duty. Also, the police on completion of investigation in Paltam Bazar PS case number 465/2024, submitted a charge sheet being charge sheet number 33/2025, and therein one Dhiren Tati was arraigned as an accused. Also, the charge sheet being filed, the Court of the Learned Chief Judicial Magistrate, Kamrup bracket Metro Gauhati, had made over the case to the Court of the Learned Judicial Magistrate First Class Kamrup for trial. It is projected that the trial in the said case is presently underway. The Learned Counsel for the petitioner submits that, considering the materials coming on record in the charge sheet, there was no occasion for the respondent authorities to proceed against him departmentally. Also, it is in the above backdrop that the petitioner followed, very good. It is in the above backdrop that the petitioner, by order dated 19/2/2025, came to be placed under suspension. 19/2/2025, issued by the Director of Tea Tribes and Adivasi Welfare, Assam, came to be placed under suspension. Also, the order of suspension was projected to have not been reviewed and a departmental proceeding not been instituted in the matter. The petitioner has instituted the present. Mr. S. Bhattakur, Learned Senior Counsel, after reiterating the facts noticed herein above, has submitted that the suspension of the petitioner occasioning with the issuance of the order dated 19/2/2025 was so continued with in clear violation of the decision of the Supreme Court case of Ajay Kumar Chaudhary versus Union of India, reported in 15/7 SCC 291. He submits that the respondent authorities had also instituted a departmental proceeding against him by issuance of a show cause notice dated 26/12/2024. Also, accordingly, Mr. Gauhati submits that the impugned order of suspension, having been continued in violation of the directions passed by the Honorable Supreme Court in the case of Ajay Kumar Chaudhary, the same would mandate an interference. Having made the such submissions, Mr. Gauhati, by referring to the additional affidavit filed in the matter by the by referring to the affidavit in reply filed in the matter by the petitioner, has submitted that the respondent authorities subsequently have instituted a formal departmental proceeding against the petitioner by issuance of an order dated 24/6/2025. Mr. Gauhati submits that in view of the materials coming on record in the charge sheet filed by the police in connection with Poltam Bazar PS case number 465/2024, and therein the petitioner not being arraigned as a accused, the allegation now leveled against the petitioner in the show cause notice dated 24/6/2025 would not be maintainable, and the same would mandate an interference from this court. Also, per contra, Ms. M. Bhattchaji, learned counsel for the learned additional senior government advocate, appearing for the respondent authorities, has submitted that the petitioner, being the custodian of the missing 96 numbers of smartphones, he cannot shirk his responsibility in the matter, and there admittedly being a loss of government property, the institution of the departmental proceedings against the petitioner not mandate in this court. It is submitted that the petitioner was suspended from his services after a due inquiry in the matter was conducted, a joint director of the directorate, and the same having brought on record that the petitioner, being the custodian of the missing smartphones, he is responsible for the same. Accordingly, Ms. Judge submits that the petitioner's suspension, in light of the fact that a departmental proceeding has already been instituted against him, would not mandate an interference by this court. He further prays that the respondents be permitted to take the departmental proceedings instituted against the petitioner to its logical conclusion. I've heard the learned counsel for the parties and also perused the materials available on record. At the outset, this court would consider the challenge presented by the petitioner to a show cause notice dated 26/4/2024. The said show cause notice has been annexed to the writ petition as Annexure G. The said show cause notice being relevant, the contents of the said show cause notice being relevant, the same is extracted herein below. Page 48A. A perusal of the said show cause notice would reveal that the petitioner was directed to submit his clarification with regard to the loss of missing of 97 numbers of smartphone kept in the museum hall at the third floor of the office premises of the directorate. It was further projected that the key of the lock of the museum hall was kept with the petitioner since 19/5/2020. What is relevant to notice with regard to the said show cause notice dated 26/12/2024 is that the same only requires the petitioner to submit a written explanation of his conduct and to provide a valid cause as to why disciplinary action should not be initiated against him under Rule 9 of the Assam Services Discipline and Appeal Rules 1964. So the above being the content of the show cause notice, this court is of the considered view that while the same, no departmental proceeding can be said to have been initiated against the petitioner herein. Accordingly, the challenge made by the petitioner to the said show cause notice dated 26/12/2024 in the considered view of this court is on a misunderstanding of the matter, and the said challenge would not be maintainable inasmuch as this court does not find a departmental proceeding to have stood initiated against the petitioner while issuance of the said show cause notice dated 26/12/2024. Also, having drawn the said conclusion, this court would now consider the suspension order dated 19/2/2025. The order dated 19/2/2025, issued by the Director, Tribes and Adivasi Welfare, Assam, placing the petitioner under suspension. Also, the respondents in their there were some review orders. Where do I get that?
Your Lordship review definitely that
Extension orders.
extension order is there. Lordship, that's in page 131.
Your reply
Yes, our reply, Lordship.
finds that the order dated 19/2/2025, placing the petitioner was considered by the review committee, considered in the meeting of the review committee held on 25/6/2025, and the suspension of the petitioner was extended till 17/8/2025. Also, from the materials brought on record, it is revealed that there was no review prior to the said review review. There was no review of the suspension or the review of the necessity to continue to place the petitioner under suspension prior to the consideration so made by the review committee in its meeting held on 25/6/2025. Also, the issue with regard to prolonged continuance of an order of suspension was considered by the Honorable Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291. The conclusions drawn by the Honorable Supreme Court in para 21 of the said decision, being relevant to the arising in the present writ petition, the same is extracted herein below. Judgment of para 13, 14, so, quote para 21. A perusal of the provisions of para 21 of the decision of the Honorable Supreme Court in the case of Ajay Kumar Supra would reveal that an order of suspension would remain in currency only for a period of 3 months from the date of issuing of the same, in the event, no show cause notice instituting a departmental proceeding against the delinquent, was so issued. It further stipulates that in the event a departmental proceeding is so instituted within the period of 3 months from the date of issue of the order of suspension, the respondent authorities are to pass an order after reviewing the necessity for continuing the delinquent under suspension. Also, this court finds that the respondent authorities had issued the show cause notice to the petitioner on 24/6/2025. Also, accordingly, the said show cause notice admittedly was issued beyond the period of 3 months mandated for continuance of a order of suspension, before order of suspension before without institution of a departmental proceeding in terms of the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary. Also, the departmental proceedings against the petitioner admittedly having been instituted after a period of 3 months, after a period of lapse of more than 3 months from the date of issuance suspension of petitioner, this court is of the considered view that the order of suspension of the petitioner had lost its force and accordingly cannot be held to be continuing, to be subsisting as on date. So, the petitioner consequently would be entitled to be reinstated in this. Also, accordingly, for the reasons noticed herein above, the petitioner is directed, the petitioner is directed to be reinstated in services forthwith. Also, the orders towards reinstatement of the petitioner in his services be issued by the Director, T Tribes and Adivasi Welfare, Assam, immediately on receipt of a certified copy of this order. Also, this court would now consider the prayer of the petitioner, the Dalan Senior Counsel, for an examination of the show cause notice dated 24/6/2025, issued to the petitioner, instituting a departmental proceeding against him. This court finds that the said show cause notice dated 24/6/2025 was so issued after the instant writ petition was so filed before this court on 11/4/2025. The show cause notice dated 24/6/2025 is not found to have been assailed by the petitioner in the present writ petition. Accordingly, this court would not proceed to examine the validity of the show cause notice dated 24/6/2025 in the present writ petition. However, liberty is granted to the petitioner to institute appropriate proceedings, if so advised, to assay the said show cause notice dated 24/6/2025. With the above observations and directions, the present writ petition stands disposed of.
Much obliged.
Ms. Bhattchaji will be appearing for all the respondents here. This is T-board and all those things.
He tried this in a day.
Because an affidavit was filed. Tree Tribes, Assam, Directorate of Tree Tribes and Adivasi. I had to take it. Yes. Yes. Yeah. 7 to yeah. It will give me on. Yes. Huh?
Criteria for. Therefore.
But have you passed an order? Then?
No person order was issued.
Oh, no provincialization order was issued. Oh.
My lord. My lord, if that is, my lord, but regarding this, my lord, Toron Chandranath, my lord, can it be possible to issue, my lord, because that has to be ascertained, because.
No. That you ascertain where you want to go, but they find that the school is not liable to be provincialized. So everything falls through. We'll record his statement and we'll close the matter, giving you liberty to take appropriate steps as may be mandated under law. Mr. B.K. Das, Learned Counsel for the petitioner. Also heard Mr. P. Sharma, Learned. P.N. Sharma, Learned Counsel for the Learned Standing Counsel, Secondary Education, Elementary Education Department. Mr. P.N. Sharma, at the outset, by referring to the affidavit filed by the Director, Elementary Education Assam, submits that prior to issuance of the provincial order provincializing the services of the teachers found eligible in Karki Chuk Janajati ME School, it had come to the notice of the respondent authorities that the school in question was granted recognition by order dated 14/2/2006, that is after the cutoff date of 1/1/2006 as prescribed under the provisions of Section 3 bracketed Dangor 1, bracket over, bracket Roman I small of the 2017 Act of Pura Likhiyo Paribi of the Act of 2017. Accordingly, it was held that the school was found to be ineligible for provincialization of the services of its employees. So, the said situation is not disputed by Mr. B.K. Das, Learned Counsel for the petitioner. Before issuance of provision. In view of the above position, the claim made by the petitioner herein for provincialization of his services in Karki Chuk Janajati ME School would not mandate a consideration. Also, accordingly, the present writ petition stands closed. However, liberty is granted to the petitioner to institute appropriate proceedings to establish the eligibility of the said school under the provisions of the Act of 2017 for having the services of the teachers working in this school to be provincialized.
All right.
Aruki Yasin. Heard Mr. Ayat Soikia, Learned Council, and also heard Ms. M. Learned, Additional Senior Government, appearing for respondents. The petitioners who all of them are, the other 3 and 5 are continuing till date. Huh?
No, my lord.
What is the name of 3?
Please, my lord.
65. Okay. They have gone. Who were employees of the Assam Hills Area Development Corporation Limited have approached this court by way of instituting the present petition, praying for a direction upon the respondent authorities to release their areas after computing their pay with effect from 1/1/2006 in terms of the ROP rules of 2000, Assam Services Revision of Pay Rules 2008, right? 2008. It's 2008. Revision of Pay Rules, Mr. Not 2008. No. State 2010. 2010. 2010.
With effect from
And
2006.
And with effect from 1/1/2016 in terms of the ROP, Assam Services Revision of Pay Rules 2017. So, the petitioners herein were serving in various posts in the Assam Hills Small Industries Development Corporation Limited, hereinafter referred to as the corporation. It is projected that the corporation is an undertaking of the government of Assam and is fully managed and controlled by the government. So, the petitioners, after the provisions, after the revision, Assam Services, revision of pay rules 2010 was implemented, for the state government employees, the petitioners and the other employees working in the corporation at the relevant point of time were continued to be paid their dues in terms of the adoption made by the corporation of the provisions of the 5th Assam Pay Commission. So, the benefits under the ROP rules of 2010 and the rules of 2017 not being extended to the petitioners, the petitioners, along with other similarly situated persons, had approached this court by way of instituting a writ petition, being WPC number 1435/2012. A coordinate bench of this court, wide order dated 19/2/2019, on considering the issues arising in the said writ petition, and also noticing the submissions made by the learned counsel for the respondents, proceeded to dispose of the said writ petition. By observing that technically, the state government may not be liable to extend financial support to the corporation, but in view of the financial difficulty faced by the corporation, the state government, the government in the Hills Department as well as the Finance Department may consider extending financial assistance to the extent possible. It was further observed that the corporation shall also continue to pay the petitioners their current and area salaries by devising a method particularly to clear the area dues in a phased and expeditious manner. So, it is from the records, from the materials brought on record, this court finds that the board of directors of the corporation, in its meeting held on 4/8/2016, and upon a thorough discussion of the issue, decided to pay the revised scale on the basis of the 6th Pay Commission report without giving revised pay areas to the employees and workers, subject, however, to availability of administrative fund / surplus fund of income from various sources. It was further decided that the revision of pay scale will be effective only for existing working employees of this corporation, subject to the revenue position depending on income of sales, proceeds, etc., when the management thinks fit, and also subject to approval of the government. Also, it is further found that the government provide a notification dated 24/8/2012 had noticing the difficulty faced by state-level public enterprises in the state of Assam in pay fixation, after with pay fixation in the revised scales of pay, had required all state level public enterprises to submit their proposal for pay revision to the finance department through their administrative department. Thereafter, by the notification dated 24/8/2012, the government of Assam in the finance department, finance bracketed PRU bracket over department, had laid down the procedure to be followed for adoption of the pay scales coming into force in pursuance to the Assam Services bracket revision of pay bracket over rules 2010, for its officers, subject officers. A perusal While the said notification dated 24/8/2012, it was mandated that the board of directors of each state level public enterprise shall decide to adopt provisions regarding revision of pay, pay scales, allowances, and payment of area of pay as per the provisions of the said rules of 2010. Also, after making a detailed examination of the financial involvement. Also, it was further provided that the pay revision is to be allowed with the approval of the concerned administrative department only after the board of directors agree that the concerned enterprise has adequate financial resources to meet the expenditure for paying the revised pay, revised allowance, and the area pay. It was further stipulated that before allowing the pay revision by the administrative department, each of the SLPs would be required to sign a memorandum of understanding with the administrative department, indicating the exact number of posts and number of employees working against the sanctioned posts. So, the petitioners herein, by projecting that although a procedure was laid down by the government in this kind of for adoption, for payment of revised pay to the employees of the respondent corporation, the board of directors having already adopted the revision of pay rules 2010, in its meeting held on 4/8/2016, the non-disbursal of the amount involved to the petitioners had violated their rights in the matter, violated their rights under Article 21 of the Constitution of India. So, accordingly, the petitioners had instituted the present writ petition. Mr. Ayat Saikya, Learned Counsel for the petitioner, has reiterated the facts noticed herein above and has submitted that the board of directors having already adopted a resolution for implementation for revision of the pay and allowances of the officers and employees of the corporation in its meeting held on 4/8/2016, this court would be pleased to direct the respondent authorities to further process the matter and to take the issue to its logical conclusion. It is submitted that the petitioners are all now advanced in their are all in the advanced age, and they are in dire need of money for making their ends meet. Also, he submits that the respondent corporation is contented to be making profit as of now, and accordingly, a decision in the terms of the policy laid down by the government in the notification dated 24/8/2012 is mandated to be taken in the matter. Per contra, Ms. M. Bachaj, learned counsel for the petitioner, for the respondents, submit that the revision of pay of the employees of the corporation is a matter to be decided by the board of directors of the corporation after ascertaining the feasibility of the same. She submits that in the event the corporation has the ability to bear the additional expense coming into existence on account of affecting revision of pay of its employees, the corporation must meet the same through its own resources. She, however, submits that the corporation has already expressed its inability to meet the additional expenditure. Ms. Bachaj submits that under such circumstances, this court would be pleased not to direct the government to make provision for payment of the revised scale of pay to the petitioner either under the 6th Assam Pay Commission or the 7th Assam Pay Commission. Also, I have heard the learned counsel for the parties and also perused the materials available on record. As noticed herein above, the procedure mandated to be followed for revision of pay in establishments like the respondent corporation was laid down by the Finance Pay Research Unit Department by the notification dated 24/8/2012. Also, in terms of the said notification, a decision at the first instance is to be arrived at by the board of directors of the corporation after examining the feasibility of providing for revised scale of pay to its employees. Thereafter, the proposal is to be sent to the administrative department for a further scrutiny. Also, at this stage, in the event the administrative department is of the view that the corporation has adequate funds at its disposal to meet the increased expenditure coming into being on account of implementation of revised scale, on account of revision of scale of pay of its employees, the administrative department can permit the corporation to go ahead. However, it is stipulated that before granting of such permission, a memorandum of understanding is to be entered into by the administrative department with the corporation. In the case on hand, this court finds that the board of directors of the corporation in its meeting held on 4/8/2016 in principle had agreed to adopt to revise the scale of pay of its employees in terms of the ROP rules 2010, revision of pay rules 2000. Also, however, on a close perusal of the said resolution, it is found by this court that the same was made effective only for existing working employees, and the same was further made subject to the revenue position depending on income of sale proceeds, etc., and also when the management deemed it fit after approval of the government. The perusal of the said resolution of the decision of the board of directors as arrived at in its meeting held on 4/8/2016 this court does not find a clear decision taken for revision of pay of the employees of the corporation. And further, Also, further, this court does not find that the said decision, even if it is assumed that the decision to revise the pay of the employees of the corporation was arrived at, the same was further processed in terms of the notification dated 24/8/2012. Accordingly, it is found that the corporation, considering its financial position, had not further proceeded to actually implement the revised scale of pay for its employees. Also, the learned counsel for the petitioner in this connection had made a submission that this court is required, that the corporation being a state government undertaking, this court would direct the respondent state to provide for a grant to facilitate a revision of pay of the employees. Also, this court finds that the said submission of the petitioner to be not acceptable. The respondent corporation is an autonomous body, and merely because the government has a controlling share in the said corporation, the liability of the corporation would also be, it cannot be held that the liability of the corporation to pay for to pay its employees their pay and allowances in the revised scale is also to be borne by the government. Also, in support of the said submission, said conclusion, this court would rely on a decision of the Honorable Supreme Court in the case of A.K. Bindal and others versus Union of India and others, reported in 2003, 5 SCC 163. The relevant conclusions drawn by the Honorable Supreme Court in this connection in para 17 is quoted herein, is extracted herein below. Para 17. 1/7. Also, this court further, also the Honorable Supreme Court in its decision in A.K. Bindal and A.K. Bindal Supra had further proceeded to consider as to whether under such circumstances the provisions of the right under flowing from Article 21 in respect 21 of the Constitution of India in respect of the petitioners herein stood violated. So, in this connection, the Honorable Supreme Court had drawn the following conclusions. Para 18. Also, further, the Honorable Supreme Court held that in its said decision held that the economic viability of an industrial unit or the financial capacity of the employer must be taken into consideration in the matter of revision of pay scales of the employees of the corporation. So, in view of the conclusions drawn by the Honorable Supreme Court in the case of so and so, and by applying the same to the facts of the present case, we find that this court finds that that no right of the petitioner for receiving the pay and allowances in the revised scale of pay dehaws a consideration of the financial capacity of the corporation to bear the additional expenses arising on account of such revision of pay being implemented. No right of the petitioner. This court finds that no right of the petitioner has been infringed in denial in the denial to them of the revised scale of pay as employees of the corporation. Such denial is found to have been so occasioned on account of the financial condition of the board of the corporation. So accordingly, the claims made in the present petition, the considered view of this court would not mandate an acceptance. So, having drawn the said conclusions, this court provides that in the event the corporation on an improvement in their financial condition decides to implement the revision of pay scales by adopting either the provisions of the Assam Services Revision of Pay Rules 2010 and or the Assam Services Revision of Pay Rules 2017 with retrospective effect, and in the event during the period and in the event it is found that the petitioner's hearing were serving in the corporation on the date when the revision of pay rules have been given a retrospective effect, the benefits thereunder be also conferred, be also granted to the petitioners herein, along with release of areas of pay. If you give it retrospective effect from that day, and if they are working, they get it. That's all. Nothing more, nothing less. R. Borpuzari, respondent number 4. Standing Counsel, Finance Department, respondent number 4. Yes. No, that cannot be extended automatically. They'll have to adopt it. Rule 2. Mr. Bhattchaji Pishor. Mr. R. Borpuzari, learned Standing Counsel, Finance, submits that a detailed procedure with regard to adoption of the revision of pay rules coming into force from time to time was required to be so made, in as much as in the revision of pay rules, a stipulation is made to the effect that the same shall not apply amongst others to officers and staff of public undertakings of the government, Assam government, comma, without express orders of the government. With the above observations and directions, the present petition stands dismissed. I'll just make some. AK Bindal to Kimanosan citation to 1000. Which? Yes. Mr. Kumar, after a long time.
I have a small matter at item number 38.
38.
38 means it's a pension matter. Today the government was supposed to give the instruction. From January, they are not getting the pension.
That GMC matter.
Yeah, within which date they will give.
You were receiving pension earlier.
Yes.
Now why it is stopped?
Very irregular. If it is to given
That nobody is paying taxes, that means in this state, in the city.
They think that these are not like the which are given before election. These are considered as nowadays as bounty, I suppose, which should not have been. So they were supposed, Mr. Gogoi was supposed to bring.
So for that, I will require all the councils appearing in the matter to file whether they have filed their returns with the property tax to the GMC. Since the councils appearing in the matter. If you have not filed, then
I'm living in my father's house, so I have no problem.
You did not.
He may have made a will without knowing, but today.
No, that annual tax you have to pay to GMC.
If you have your property in your name, if you don't have, then free. You can take.
Then from where will GMC pay your clients? If that is the attitude of the citizen. So we reject your case.
Yes. But first we'll hear the instruction of Mr. Gogoi. I'll ask someone to call.
You can, when the moment it is available, just let me know. You have, what is it?
Because these are old people, my lord, waiting for their treatment and all. They said that some of them had died even during the pendency of this writ petition. That's our only.
10,000 petitions.
And there are about 2,000 members of this issue. The last order is of 3/6.
Oh, they are, Mr. Kumar, they are processing the matter. Now the matter, after the meeting all the queries, is before the competent authority in the finance department for obtaining approval.
That was it.
You give him. Mr. Kumar is more comfortable with the tab.
My lord, almost 235 pages instruction with all the my lord chronological records. No, I have only furnished the.
We don't want. We want whether the money is their entitlement.
No,
Entitlement is there. Different now.
The entitlement is there. There is no dispute. Only there is that they have stopped paying it from January.
No, for that, the finance is not responsible. For that, the GMC is responsible. They'll have to find out resources.
So GMC said that the
GMC cannot always rely on the government for aid. They'll have to work out their own.
Yes. But on the last occasion, if your lordship looks into the order of 3/6, he said that the State Housing Board and the finance department will be responsible. Therefore, this instruction is of 8/6. And they have even earmarked in the 7th plan for this fund so that these people, my lord, around
But
2,000.
now, without the budget coming, can this money be
It is under-
vision for?
It is under examination, my lord.
You say 2 weeks.
Therefore, Lordship will accommodate me for 2 weeks. I will come up with updated.
Okay, done.
Because-
My lord, but your lordship fix it
Because-
because this.
We'll fix it before vacation, don't we?
One thing.
Heard Mr. Item number?
38.
Just materialized, my lord. 2nd of June 2026.
I got it, I got it.
Because we act on the proposal, my lord. The amount in.
Mr.
there is, my lord, 12.
Mr. Borpuzari, nothing against you. This court will have nothing against you. This is a responsibility of the GMC. The government is gracious enough to take this. We appreciate that. But Mr. B.D. Kaur, learned senior counsel, assisted by Ms. M.S. M. Kaur, J.M. Kaur, learned counsel for the petition. Also heard Mr. R. Borpuzari, learned standing counsel, finance department. Mr. Borpuzari, basing on instructions received, has submitted that a proposal was received from a proposal for financial sanction was received from was received by the finance department from the Gauhati Municipal Corporation for release of pension to its retired employees. Mr. Borpuzari submits that after a detailed deliberation on the matter with the Department of Housing and Urban Affairs and on a reply being received to the queries raised by the Finance Department, the matter is now placed before the competent authority of the Finance Department for seeking approval before the competent authority for seeking approval. He submits that he be granted 2 weeks' time to apprise this court with regard to the further developments taking place in the matter. Mr. B.D. Kaur has expressed an urgency in the matter by projecting that the petitioners in the present writ petition are all aged and suffering from old age ailments, and according an early resolution of the issue involved would be in the interest of the petitioners. So, considering the prayer made by Mr. R. Borpuzari, learned standing counsel, finance department, this court, the registry is directed to list this matter again on 23/6/2026. Mr. Borpuzari, on the next date of listing, shall apprise this court with regard to the further developments taking place. Shall apprise this court as to whether the amount as sought for by the Gauhati Municipal Corporation for release of pension to areas of pension to its employees has been approved by the finance department.
My lord, this 12 crores is in regard to area, but what about the current pension, which should be paid, my lord, every month?
That too. That will be by the corporation. Let's see on the next.
Yes,
we'll see.
we are deeply obliged, my lord.
A copy of the instructions furnished by Mr. So-and-so, Mr. R. Borpuzari, is kept on record and marked as X for the purpose of. See what you can do.
If I may make a short, my lord.
25th, done. 25th will be too late.
24th.
24th.
23rd, my lord, some difficulty.
No problem. 24th, no problem. 24th.
We are obliged for accommodating being. I can at least leave early.
Yes. Senior citizens, not you, your petitioners. Yes, Mr. Kaur. What do you want to do here?
See, similar matters on 16 July.
Oh, that is different.
They are claiming.
Now they get it.
Your lordship, in the PNRD,
These plus are series of higher as institutions.
Is what I want to know. Where is your affidavit, Mr. Moore? You are going to face a big thunderstorm.
Yes, yes,
I'm telling you.
yes.
And you have this matters are pending from 21. You have not even cared to file an affidavit. That is why when you came, I liked it. Because this is a serious matter.
Yes, yes.
And we can pass orders now. There is no problem. We are backed by Supreme Court decision. But
Just in this time, you know.
Mr. P. Kaur, learned additional, K. Kaur, learned additional Advocate General appearing for the Panchayat and Rural Development Department submits that he be granted time till 1870 till 18/6/2026 to file an affidavit on behalf of the respondents represented by him. Pray accepted. The respondents shall invariably file their affidavit on or before 18/6/2026. No further adjournment shall be granted in the matter. Registrate to list this matter again on 19/6/2026.
Leave to apply, sir.
Delivery of we will. Yes. Where is the respondent?
Shiv, I believe he has left.
Full board is in Lingi. Take me soon. Okay. Had Mr. A.K. Ghosh, learned counsel for the petitioner. Mr. Bora had appeared. Who had
Yes.
appeared? D. Bora had. Also heard Mr. D. Bora, learned government advocate, appearing for the respondents. Mr. Bora is available? Just call him. Take it up after 2 minutes. All of Likilo. Also, the petitioner in the present writ petition has presented a challenge to an order dated 1/11/2021 issued by the Commandant 7th AP Assam Police Battalion, Torai Hola, Kokrajhar, imposing upon the petitioner a penalty of stoppage of 2 increments with cumulative effect. Also, the petitioner hearing, while serving as a
Barber.
barber, grade 4 employee, in the 7th Assam Police Battalion, Sorai Khola, Kokrajhar, was involved in a the petitioner, while serving, an FIR came to be lodged against the petitioner while he was serving as a barber in 7th APBN, Sorai Khola. The said FIR was so lodged on 15/5/2021. The police, on receipt of the said FIR, registered the same as, which is the police station? Received the same as Kokrajhar PS case number 373/2021 under section 376 A, B, IPC, read with section 4/7 of the POSCO Act. Also, the petitioner was placed under arrest in connection with the said police case on on 15/5/2021. So the petitioner on being produced before the learned trial court, comma, he was remanded to judicial custody. So the petitioner having remained behind the bars for under detention for more than 48 hours, comma, the petitioner was the commandant 7th APBN, comma, Soraikhola, Kokrajhar, proceeded while order dated 25/5/2021 to place the petitioner under suspension. Also, thereafter, while a show cause notice dated 11/6/2021, a departmental proceeding came to be instituted against the petitioner. Also, DP number 2/2021 was so instituted against the petitioner. It is to be noted that the petitioner at the time of issuance of the show cause notice was in judicial custody. So, the petitioner on being enlarged on bail, comma, the suspension, the disciplinary authority of the petitioner, while order dated 28/7/2021, proceeded to revoke his suspension order with effect from 28/7/2021 and permitted the petitioner to resume his services. However, the same was made subject to the departmental proceedings instituted against the petitioner. The petitioner thereafter submitted his show cause reply on 30/7/2021. The show cause reply submitted by the petitioner not being found to be satisfactory, comma, the disciplinary authority of the petitioner, Mr. Ghosh, you can sit down. The disciplinary authority of the petitioner proceeded to direct for holding of a departmental inquiry against the petitioner with regard to the charges so framed against him in the show cause notice dated 11/6/2021. The petitioner is found to have participated in the inquiry. So, on conclusion of the inquiry officer submitted his report on 30/10/2021. The disciplinary authority of the petitioner on considering the findings of considering the inquiry, the materials coming on record in the inquiry, comma, the inquiry report, proceeded to concur with the findings of the inquiry officer and imposed a penalty of stoppage of 2 increments with cumulative effect on the petitioner. It was further provided in the order that the same may be revived later on, basing on the orders passed in the criminal proceedings instituted against the petitioner. Also, it is further projected that on conclusion of the investigation in the matter, the police had submitted a charge sheet against the petitioner under Section 376 AB of IPC, read with Section 6 of the POSCO Act. After completion of the requisite formalities, the trial commenced in the matter. Also, on conclusion of the trial, the trial court, while judgment and order dated 9/11/2022, proceeded on examination of the materials evidences coming on record, proceeded to acquit the petitioner from the charges leveled against him under section 376 AB of IPC, read with section 6 of the POSCO Act, and he was set at liberty forthwith. So, the petitioner, on being acquitted in the criminal proceedings instituted against him, acquitted by the learned trial court, approached the respondent authorities for an interference with for a recall of the order dated (1/11/2021), imposing upon him a penalty of withholding of or penalty of stoppage of 2 increments with cumulative effect. The said prayer of the petitioner not having been considered. Also, the said prayer of the petitioner. The appellate authority of the petitioner, on consideration of the prayer made by the petitioner in this connection, proceeded while order dated 7/10/2023 to reject the same. So, being aggrieved, the petitioner has instituted the present writ petition. Mr. A.K. Ghosh, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the allegations leveled against the petitioner, both in the criminal proceeding as well as in the departmental proceeding, was one and the same. The trial court, on a due examination of the evidences coming on record, including the evidence adduced by the by the victim girl, having found that the petitioner was not having found that the allegations leveled against the petitioner to be not established, and the prosecution having failed to prove the foundational facts as mandated for establishing a charge under POSCO Act, having proceeded to set the petitioner at liberty, the departmental authorities could not have in the matter arrived at a conclusion contrary to the same. Mr. Ghosh, by referring to they have not even argued this, referring to the inquiry conclusions drawn by the inquiry officer in the inquiry report, submits that there is no discussion with regard to the evidences coming on record in the inquiry, and only by referring to the arrest and detention of the petitioner in the criminal proceeding, the charges leveled against the petitioner was held to be established. He submits that the same would mandate an interference from this court. Mr. Ghosh has submitted that in view of the materials coming on record, the penalty as imposed upon the petitioner by his disciplinary authority, wide the order dated 1/11/2021, would mandate an interference from this court. So, anything more? We'll hear Mr. Bora also. At the parties at some length. Hearing remains inconclusive. Registry to list this matter again. On Thursday for further hearing. I'll pass the balance order after hearing Mr. Bora.
The case was regarding payment of arrears. The state was supposed to file an affidavit.
Yes, Mr.
My lord, directed to.
Okay. Heard the learned counsel for the parties. Mr. P. Talukda, learned Standing Counsel Elementary Education Department submits that the affidavit on behalf of the respondents represented by him is prepared and would be filed on or before any day, tomorrow. That you will know, can I know? Then 1 week, after a week. So, prayer accepted. Respondents to invariably file the affidavit on or before 19/6/2026. Thereafter, the petitioner is permitted to file his rejoinder thereto on or before 26/6/2026. Registry to list this matter again on 17/7/2026 for admissions.
Obliged, deeply obliged.
Lord, may I plead for taking this matter up after some time? Mr. S. Bhattakur will.
The question is, which is the notification
Applicable
that will be
guidelines.
applicable? Where is the notification of 28/7/2022 or for the matter 2017? Copies are not here.
28/7/2022 is at page number 69.
That is for the guidelines for your no, where is that guidelines?
Page number 69, Lordship.
69. We got it, but what is the procedure?
Lordship, at page number 72, which was adopted by the state for the provincialized colleges also.
Eighteen 5/2017.
Your lordship will peruse your lordship's order, your lordship. At pay, dated
22.
Lordship. In fact, all others were appointed, your lordship, person based on this.
Yes.
Yeah. An earlier appointment was also approved based on the same selection criteria, your lordship, which we put to challenge in earlier round of litigation, your lordship. And now when our turns come as per the direction of the honorable court, your lordship, then they find that this is not as.
There was a person who scored lower marks than you who was approved for appointment.
Lordship. And then they have approved it, your lordship, appointed him.
But for your challenge here, that
Lordship.
person would have been working.
Lordship.
And the other two who were given from the same selection for different.
They are continuing, your lordship.
Yes, Mr. Das.
Second case,
So if that is a error of proposal, if the procedure is wrong, their service also should go. You have not touched them.
no.
And there was a long drawn litigation before this court in the earlier round filed by the petitioner. And therein this court came to a conclusion that no, he scored more marks than the other. You never raised a plea that this procedure you have not followed. Now you file big things, say many things, whether those would be germane to the issue. Anything more?
Lordship, that much, your lord.
You have the full power to cancel a selection, but that cancellation must be based on some intelligible reason.
Lords.
I don't find that. No, sir, Khali. एक मिनट sir. नहीं. All are full. Okay. But Mr. S. Bhattaku, Learned Senior Counsel, assisted by Mr. S. Day, Learned Counsel for the petitioner. Also heard Mr. S. Das, Learned Counsel. Learned Standing Counsel. Petition.
1 and 2.
Appearing for the respondents number 1 and 2. And Madam, you? For the respondent number 3 and the 2, 4, and 5 data. Madam, you are for 3 and 4, 3 and 5, and you are for 2 and
1 and 2.
1 and 2. Who is 4?
4 is selection committee, your lord.
College.
College, your lord.
You can appear. 3, 4, and 5. Madam. Hearing remains inconclusive. Registry to list this matter again on liaison. Kali Puruhi Taragot 12.
Lords. Deeply, your lord.
But you will not get any back wages. You will only get a notional
Not
thing.
required, your lordship. That will be enough, your lords.
No. Hearing.
26.
Maybe lordship.
Wait.
Lord, the matter is very small, my lord.
No. Let your senior come. We'll hear him.
Lordship already.
You come. You are appearing for whom?
Private respondent, my lord.
We had requested Mr. Ganguly to get some instruction. 2 certificates were there.
Yes, my lord.
What is that? No. Whether the loan was closed on 10/5/22 or 23. That's the only thing I want.
My lord,
Very easy.
my lord.
You try.
Not Wednesday, any other day, my lord, except Wednesday.
After the vacations.
No, my lord, except
Disputed question of.
No, my lord, only Wednesday. I have some personal problem, my lord.
Right.
That is why.
As prayed for by Mr. A. Ganguly, Learned Counsel, as prayed for by the Learned Counsel for the parties, registry to list this matter again on 12th.
Hello, please.
Madam, once we on that point come, if we come in his favor, other points we are not going into. We'll allow.
Hello.
Yes, Mr. Soma.
Lordship, I was an employee of the respondent bank. On 18/12/2007, one of the customers of my branch has filed an FIR alleging that out of 5 numbers of FD he has kept with me, there was 3 demand loans created out of that. And
Mr. Ganguly, you are paying for the respondent.
I think hinges on that criminal filing.
I know that.
He is a convicted, but. 5
5-year-old. As on today, the best step that he can take life is acquitted. He found to be reinstated.
Oh, let us do something either way.
Lordship,
Just a moment, Mr. Sharma. So you all are very impressed. Let me also get somewhat knowledgeable about the whole thing. Okay. Where is the order passed by the revision court? You have not annexed that, Mr. Sharma?
which one's?
The page?
64, 65.
Only the sentences state. Where is your conviction state?
That is not the issue, Lordship. Main issue here is if we see the impugned penalty order, that is in
Where
page,
is it?
page 39. Page 39. So and so, in pursuance to the judgment in the court of the Chief Judicial Magistrate, Karimganj, Assam on 17/7/2018, in GR case number so and so, the following punishment is awarded to you in terms of Regulation 30, subsection regulation 3A and B of Assam Gramin Vikas Bank, Officers and Employees Service Amendment Regulation 2013, and Section 10(1)(b)(1) of the Banking Regulation Act.
You want your gratuity. GLSSI has been given to you.
GSL has been given.
Only the gratuity.
No, Lordship, here is the procedural irregularities are there. I am pointing out that only. And then, Lordship, let us examine the Regulation 30, Sub-Regulation 3A, B, and
Where do I get it? It is there. You have annexed it. Yes.
I have annexed it. It is in page number 90.
90.
Page number 90. Third para.
3A.
3A. An officer or employee shall be liable to dismissal or any of the other penalties. I repeat, Lordship, dismissal or any of the other penalties referred to in Regulation 39. If he is committed to prison or death or is convicted of an offense which, in the opinion of the competent authority, either involves moral turpitude or has a bearing on any of the affairs of the bank or on the discharge by the officer or employee of his duties in the bank. An opinion in this respect of the competent authority shall be conclusive and binding on the officer of the employee. Now let us, Regulation 9 is regarding penalty. Regulation 39 is regarding penalty. And to impose penalty, major penalty, departmental proceedings is a must.
No.
But
sorry, it is, you have been imposed this penalty because of your conduct, which led to your conviction in a criminal case.
That is true, Lordship.
Where is the question?
Regulation 40, Lordship.
Mr. Sharma, settled position of law that 311 second proviso B or C. If there is a conviction, the employer can impose a penalty without following the procedure.
That is
tomorrow, if your criminal revision is allowed, you get back everything.
That is true, Lordship. Let us examine the Regulation 40 of this staff service regulations. That is in page number 95. These requirements can be waived, Lordship. There are certain preconditions. The requirement of Regulation 39 may be waived by the competent authority if the fact on the basis of which penalty is to be imposed on the officer or employee have been
Against you, where the officer has been convicted on a criminal charge.
that provided, Lordship, last paragraph of 40, provided that no requirements of regulation 39 may be waived unless the reasons for doing so are recorded in the writing and placed before the board. That has not been done in an instant case. The impugn order has been issued by the
Mr. R.K. Sharma, Learned Counsel for the petition, also heard Mr. A. Ganguly, Learned Counsel for the respondents. The issue involved in the present writ petition would require a deeper consideration by this court. Accordingly, admit. Is there a stay order? No stay order? Admit the writ petition for hearing. Registry to list this matter for hearing on 3/8/2026. We'll consider. And by the time, get your criminal revision out of the way. Oh, fine. Yes, madam. What do you say? Compassionate allowance.
Lordship, we have received the affidavit.
Oh, fine. Forget the affidavit. We'll not go into the affidavit. Now tell me why the compassion should be there. And what is this filing of writ petitions without annexing all the pages of the judgment? Yes. What do you have to say? It's a fraud established. It's a, what do you call that? So here the discretion is of the government, of the author employer. And if he finds this to be an act which is beyond your capacity, which you have done beyond what is normally you are required to do, you have committed a fraud, you have tried to defraud the bank, then compassionate allowance is not given. Say in a case, I'll tell you, you have been alleged to have remained unauthorizedly absent for a long period of time, right? And that charge was held to be proved and you are imposed with the penalty of dismissal. Under that circumstances, the authority may give you a compassionate allowance. But in such cases, wherein it is established beyond reasonable doubt that you had committed a fraud in Itacola branch, you had taken one of the, what you call that policy, LIC policy bonds of somebody else, and you have given, it was in your custody, 2 loans. And this High Court, ordinate bench, division bench, dismissed. Now tell me.
Supreme Court acted.
Supreme Court again.
Lordship, actually, Mr. A.R. Bhoya is supposed to appear for this.
Oh, after so much time, why, Mr. A.R. Bhoya? You argue.
No, Lordship.
Mr. Bhoya is now senior. He can't come everywhere. Get him. Today itself.
No, Lordship, he already left.
Or left online. I can't read this brief once more. Impossible for me. He's not feeling well. Kali, first item. First item means after the Kali Kanagri. Upon a prayer made by Mr. A.R. Bhiya, Learned Senior Counsel, registry to, not objected to by Mr. S. Nath, registry to list this matter again tomorrow.
Mayor will. They are supposed to file affidavit, Lordship. That is all as to why the name of the petitioner is.
Mr. Decca.
Lordship.
You have received salary till when?
2006, Lordship.
2006,
Lordship.
not till 2007.
No,
You have completed junior basic training.
No, Lordship.
Then you are
So
not
that is
there.
a tutor.
You are not there in
If-
one,
if-
you are not in two.
No, as per the criteria of the proper policy decision,
The
Lordship.
policy decision is that second category receives salary up to 2007,
Yes, but training.
but do not have any professional qualification.
Yes, that professor has JBT, Lordship.
You don't have.
That is why I should be tutor.
But you did not receive salary till 2007. You received till
No, Lordship,
2006.
I have given the example, these are teachers.
Forget example. We'll follow the provision.
No, Lordship, kindly see the
Every case, we don't want them to file affidavit.
No, Lordship.
You establish your case.
Yes, Lordship, up to 2006, they received.
Simple, that much only.
Lordship, see the
Come to page 51. Show me that you satisfied. And get the order.
51.
51. That office memo, that
No,
cabinet note.
then, but Lordship, the page 47. This is the proposal and what are the parameters, Lordship? This should be followed. This is the policy of cabinet policy, Lordship. Before
What I am saying,
parameters, page 47.
what I am saying is what was the final notification in this connection?
Ultimately, Lordship, the teachers who have not having the basic training, their services are accommodated as tutor, Lordship. And for
that, they have received salary till
no, at some point of time, Lordship. Let's see, first paragraph. Those who have drawn salary at some
No,
point
that
of time.
was subsequently amended by the finance department.
No, Lordship.
This is a cabinet note. Come to page 51, 52, 50, 51, 51. Come to page 52. What was the approval sought for? 2. This is a cabinet note, memorandum. So every department's views will be incorporated. This is the final view.
But
I feel that I forgot. They don't want to file any affidavits.
No, that is why, Lordship. Last time also, Lordship. But teachers who are, Lordship, getting
You have
drawing
sent it
salary.
to where? Delhi? Then? Peaceful. Highly para. Highly. Jam is there. Night time also nowadays jam. Can't help it. Mr. A. Fukan, Learned Counsel for the respondent, Standing Counsel, elementary education submits that the affidavit on behalf of the respondents represented by him would be invariably filed on or before 15/6/2026. Registry to list this matter again on 17/6/2026.
Well,
you don't nothing we want the final policy. That's all. That this is the guidelines. I think you have filed enough affidavits on this. I forgot my order also.
Yeah, no, they have admitted for even for 2 months, 3 months, the teachers drawing salary and ultimately accommodate their service as tutor, Lordship.
That you will know better because you were there.
Yes, Lordship. I know. Apply, Lord.
Vikram Singhal. Yes, what is this?
No, this is
the last order 26 passed by the Honorable Court.
27?
27, 4/20. Lordship, you have posed a question of maintainability because the agreement is in existence.
Oh, that
Yes,
case.
yes,
Okay.
They have to address on maintainability.
Why should I 4 o'clock hear the maintainability?
Lordship will hear the entire matter. I'll take hardly 15 minutes time. my lord.
You take 15 minutes. But to translate that, it will take me ages.
No, Lord, I'll just show a few papers. There is some urgency in the matter, my lord.
How come this is a bench to matter?
Lord, because of the, I think,
Academic matter.
academic matter, my lord.
Institution.
It's a College of
We
Aeronautical
have
Engineering.
applied our mind in this matter. We came prepared, but your client just moved away.
On that day, my lord,
That day,
liberty.
yes, no. He just
There is no question
took
of
a
liberty.
John.
Lordship
No.
posed the question.
No. The second day also he took time. We came fully prepared. Yesterday I did not even touch this file.
My lord, I'll assist your lordships, my lord.
Not today. You give me a date.
Lord, day after tomorrow, my lord.
Not this week, next week. Preferably after vacations, but for you next week.
My lord.
16th,
And Mr. Das, just a query. Once you have given up everything, given away everything, now you want a part of that. How?
I can satisfy your lordship. I'll satisfy my lord.
I think too much of civil matters are involved here.
No, no, my lord. I am
On the
specifically against the impugn
council
order.
body parties, when?
16, my lord.
16. 16.
Lord, if required, we'll make a mention, my lord, some upgradation if required, my lord.
You satisfy me once you have sold it out. Complete.
No, my lord.
Yes.
My lord, they are relying on that agreement to shift the college.
Anything you can do.
No, my
You
lord.
gave away the management of
No,
the
any
college.
project, my lord, my proposition before your lordships will be. my
You
lord,
took the
my-
money. There is civil suits pending.
No
Yes,
money.
money suit, civil suit pending.
My lord, let there be civil suit pending, my lord. We are on the issue of, my lord, the validity of the impugn order. My lord, I'll make my submission squarely on that point. There may be 2, 3 civil cases pending, my lord. That is
I'm not
not
on
going to do anything in here.
Once you have to satisfy me that this college was, that the management of the college was not transferred by you to some other
My lord,
authority.
I'll.
You transferred the management, you approached, facilitated the transfer of the license in his name. Now, once that was done and the change was, place was being changed, you also agreed that you will do. Thereafter, you make a volte-face. That much only you got to satisfy.
2 submissions I'll make, my lord. First of all, the agreement which was relied on by them to act upon, all those 2 agreements were void. Number 1. Number 2 is that even assuming that those agreements are valid, my lord, even then also, my lord, the way the thing has to be done, the transfer has to be done, they have valid, my lord, assuming I have given the assurance that I'll assist in transferring the school, my lord. Now, in the same agreement itself, it has been provided how the transfer will happen.
Okay, we'll see.
So that they have violated, my lord. I'll just assist your lordship, my lord.
16, who does it mean?
Can it be at 2, my lord? If it's a humble request, my lord, if possible, my lord. Because I want to finish up this matter.
He came fully prepared that day. But
so
your client just moved away. He wanted an when I gave. Mr. Samaya, enough. Don't. The side commentaries are not required. We know.
My lord,
We'll see on 16.
in-person appearance, my lord, maybe the question he was not prepared. That's maybe, my lord.
We had
Sometimes it
reminded
happens
him
to
of
us
this,
also.
the last date of hearing. But this is what you got to explain. Not much.
No, I understand, my lord.
We'll see.
I understand, my lord. I'll try to satisfy, my lord.
Okay, okay.
I got the answers, my lord, only to satisfy your lordship.
That much only. The rest will take its own.
I'll establish your lordships that those 3 orders which are challenged herein, my lord, are on the face of the records are illegal, my lord.
That every
On the face
council
of
will say. No council will come and
No,
say.
my lord, I have a habit of, my lord, standing by my words, my lord. Much
Well,
obliged, my lord.
All by it also.
16, my lord, if
16.
possible, at 2, if possible, my lord. If
You
possible.
make a mention in the morning.
Fine, my
We'll
lord,
see.
fine. Highly obliged.
Sorry, my lord. Service was hospitalized, my lord, and
There are 2 similar matters.
My lord.
Mr. Talukdar, have you read this file? What do you get it from here?
my lord,
Why was the petitioner's salary, at least from this material, not released? Why was it not released? Forget your instruction from the records. What do you get? It's there in the records. Maybe correct, maybe wrong, but it is there. Reason is there. What did you get? Have you read the annexures? Have you read the brief? Yes or no? That's all. No. Then what assistance can you give? Come to page 43. That is the provincialization order. Now come to page 45, DEO's communication. 45. You get my page 45, you got it? That means he says his name is not recommended by DSC. Then so what is there? Why required instruction is there? After that, what? That is the instruction you get. We are here for till 45, 4:30. Yeah, here. Can you get that? Who should conduct the hearing for this? Hearing of whom? DSC members.
That's why, my lord, I pray with instruction. That's
And your officers always write in the appellate orders. As the DSC has not recommended, so we are not looking into it. Now, without DSC recommendation, SLC has cleared it. Who are the members of the SLC then? Orohi. 33, 34. We don't know about this. Hearing. Oh, what hearing? What can he say? It's yours. We want the answer on Thursday. Mr. B. Talukda submits that he would receive instruction as to the steps taken after it was alleged that the provincialization of the petitioner was so affected without there being a recommendation from the jurisdictional district level scrutiny committee. So, Mr. Talukda shall invariably place on record the steps taken by the authorities after the authorities in the elementary education department after it was brought to their notice via a communication dated 31/5/2022 by the DEO Borpeta that the services of the petitioner was provincialized without there being a recommendation made in his favor by the DLSC. Next to it.
Obliged.
ইয়াতে খালি সেকেন্ড কেসটো ডেটটো হ'ব বেলেগ হ'ব 1/6/2020 সেকেন্ডটো DEO লেটাৰটো 1/6/2022 Mr. Talukdar, once you go through this 50% of the instructions are here only. Only place that, that's all.
Your lordship may peruse the order dated 1/4/2026, your lordship.
1/4/2026. Yes, Mr. Atonia. Then you have to prepare a second syllabus. In terms of your own commitment.
One second, please.
So what is your further submission? Okay, where is that condition in the advertisement? There are vacant posts available.
Lordship, it is there.
Then?
But kindly prayer of the petitioner.
Oh, forget the prayer of the petitioner. You show me the condition.
But 33.
One is to one is FRBM. One post, one man. Posts remain vacant. You say you will fill up. Now, whether there was any corrigendum issued. This was deleted. Deleting this.
No, not deleting,
Then prescribing the criteria, madam. My lord will find it the second. Before we have filed a edition.
24 additional affidavit.
Yes.
Additional promotional.
My lord will find.
Addendum.
Case 39 of the petition.
Page
Case
39.
39 of the report.
Into question. 34. So fifth.
Hmm.
Deal number 12, my lord, preparation of marriage. Based on total come recruitment earlier advertisement for selection of last candidate merit were specified. Just you shall be. I am in the candidate earlier date of by a draw of lots. According to the
14, sir.
This is government schools, Mr. Bhattakur.
Government and provincial as both.
What is that? This is nothing to do with the criteria there.
11. 11 is verification of particulars of a past merit.
No problem. That's a draft merit list. Draft merit list is normally you can do whatever, but the merit list under FRBM should be 1:1.
Hereafter, after verification, a final list will be prepared from the draft merit list.
As per ratio 1:1. All said and done. You said even after following all this, vacancies remain. Then you will publish a further select list following the same procedure.
The original advertisement that was there, madam.
But where have you deleted that?
But in the addendum, we have specifically mentioned that after verification, a final list will be prepared from the draft merit list.
And the contention in the advertisement. Page.
Advertisement, my lord, will find at page
25.
7 is the
Huh.
relevant portion, madam.
Huh. In case any post remains vacant after filing publication of the first merit list, that is the first final merit list. As per ratio so and so, the maximum 2 numbers of list would be published. Now you have done it on the basis of merit. The persons in the top 1:1. To get to 1:1, you went 2:1. From 2:1, you went to 1:1. Even after that, you don't have candidates to fill up the post from that 1:1. So what do? FRBM gone. There is no other select list. Nobody can be. Earlier it was double the number. Earlier. Now it is 1:1. So this way has been found out that you go down the pool. After the person was considered, you go down the pool, find if there is somebody appoint. Otherwise, no. In the second round, if you fill up all posts, third select list will not be required.
That is.
But once you have made that prescription, no amendment, nothing.
But there is no amendment to this. But the addendum we have mentioned it is final list, madam. Only one list.
No.
The main
That is the final list in the first round. That is the, if you come to page 27,
that is
first merit list is
1:1.
1:1. That is the final merit list in page 39.
And your lordship will kindly note, your lordship, these are all additional information, your lordship. In addition to what is there, your lordship, already, and that is why your lordship will kindly, in the last clause, your lordship, the other terms and conditions stipulated in the earlier advertisement will remain same.
You tried. That does not
But,
convince.
while preparing the merit list, madam, our understanding is that, madam,
Your understanding cannot be beyond, your authority's understanding cannot be beyond what you have disclosed to the public.
And this probably has something to do with the rules also, your lords. Rule says, yes, vacancy will be find out, and then we'll go for selection. year wise, your lordship. So they have, that is why they have decided to carve out the vacancies, your lordship, advertise, and then to fill up till it is, your lordship, exhausted, your lordship. That is what rule also says, your lordship. Rule 8, your lordship. The recruitment to the post in the cadre of graduate teacher. Before the end of the year, the member secretary of the district selection committee constituted under Rule 16(2) shall assert in the vacancy position of the post in the graduate teacher.
Okay. Mr. I heard Mr. S. Bothakur, Learned Counsel for the petition. Also heard Mr. N.J. Khatonia, Learned Standing Counsel, Elementary. Standing Counsel, Department of School Education. Mr. Khatonia, on instructions, has submitted that the prescription as made in the original advertisement dated
20. Not today. 26/12, your lord.
26/12/2023 with regard to preparation of the final first merit list.
I don't know.
And where is that subsequent thing?
Lost.
No, that repeat that the balance vacancies would be
Is 42 years.
no, in the first case.
Lordship, I will.
Page 34, 34 minutes.
That, your lordship.
Item number 34, where do I get it?
Page 36, your lordship, in first case, your lordship. To his 5639 of 2025.
Five, 6, 3, 9. Okay.
Page 30.
Page 36. Submits that the prescription as made in the advertisement dated so and so to the effect that in case any post remains vacant after publication of the first merit list as per the ratio of 1:1, semicolon 1, then maximum 2 more numbers of merit lists would be published, was clarified by an addendum dated 16/10/2024, wherein it was now mandated that a draft merit list twice the number of vacancies would be prepared, and therefrom the final merit list in the ratio of 1:1 would be published. Also, the said submissions made by Mr. N.J. Khatonia shall be considered by this court at the time of final consideration of the present petition, as agreed to by the Learned Counsel for the parties registry to list this matter again on
next week, your
tough. Thereafter, we'll have it immediately on reopening.
Lords.
14.
Then after
On
15.
15.
One and a half.
15/7/2026. After 15. 16? 17. Okay.
17, Lord.
17/7/2020. Make a mention in the
Lord.
morning. If I am there, I'll update it.
Deeply obliged.
Lordship, it's
admitted amount, my lord, they were, my lord, regularized, my lord, with a full scale, my lord, from a particular date, my lord. But it was, my lord, subsequently given, my lord. Some period was not given, my lord.
So what is the period not given?
Period, my lord, only, my lord, full scale, they are not paid, my lord, from 1 October 2022 to February 2023, my lord.
1 October 22, February 2020.
23, my lord.
And the appointment is February 2025.
Yes, sir.
Maybe that is the time taken for your first approval of your first payment
Yes.
from the finance department.
2 months
But-
salary.
Huh?
Here, my lord, appointment are paid 74, my lord.
You were not paid from which date?
1/1/2000, March 2022. Order was passed on March.
Where is that order?
Order page 74, my lord.
And what is this 86?
Page 86, my lord. It is
Page.
confirmation. Page 74 is the order, my lord. Total, my lord, 140 numbers of teachers were, my lord, given full scale, my lord, and their effect date is given, my lord, page 75, my lord. Clause 4. Enhancement of salary as per para 1 shall be paid with effect from 1/1/2022. 1/1/2022 till, my lord, February, my lord, 2 months also they earlier, my lord, as fixed pay 8,000 they received. Full scale was not given. Thereafter, my lord.
Now you are claiming from?
Partial, my lord, as per, my lord, full scale, my lord, partial for, my lord, January, February. As per increment, my lord.
You are getting the enhanced salary. You are claiming the enhanced salary from January 2022 to February
22.
February 23.
22, my lord. 2 months, my lord, because only fixed pay they paid, my lord. They required to give me, my lord, full scale.
Only this much relief?
No, lord. Thereafter, my lord, full salary was not paid, my lord, from October 2022 to February 2023. 5 months. 5 months, my lord. Full salary.
To February 2023.
23, my lord. And, my lord, this communication director.
Wait. This order at page 74 is your scale pay?
Scale pay, my lord, full scale pay.
So from February 22 to September 22, you got your scale pay.
Yes.
Then why was it stopped in from October?
October, unknown reason, my lord, why not? My lord, lordship, page 79, my lord, this director admitted and requested the government, my lord, to sanction the amount, my lord.
Plan, non-plan post?
It is, initially there, my lord, they appointed.
Yes, Mr. Doctor. Just that information.
Otherwise, my lord, maybe, my lord, it is admitted page 79, my lord. Therefore, my lord,
What is the principle for admission?
Principle, lordship.
For this court to hold that it is admitted, what are the principles to be followed? What are the principles to be?
My lord, my humble submission is that.
Oh, Mr. Bormia, admitted. What is the principle to be followed by this court to know that it is admitted?
Yes, because, my lord, the director is the, my lord, the competent authority.
He does not support this till now. Mr. Doctor has not supported it. It will be supported when he files an affidavit.
And, my lord,
So now that you have said that it is admitted, we'll have to give him time. Even
and partial 2 months, my lord, January, February, it is admitted also page 83.
But counsel for the parties. Mr. Dr. P.P. Dr. Leonard, Standing Counsel, Department of School Education, submits that he be granted 2 weeks' time for filing a affidavit in the matter. Prayer accepted. Registry to list this matter on 15/7/2026. The respondents to invariably file their affidavit in the matter on or before 25/6/2026. No further adjournment shall be granted to the respondents to file their affidavit in the event on the next date of listing, the affidavit is not drawn on record, explaining the reason as to why the salaries of the petitioners have not been released for the periods as claimed for. This court would be constrained, considering the lapse of time occasioning in the matter, to pass directions requiring payment of the salaries of the petitioner with imposition of interest, which shall be directed to be recovered from the officials who were responsible for the delay occasioning in the matter.
Development.
May I please? May I please, Your Lordship? Herein, Your Lordship, the candidature of the petitioner was rejected in initial stage for 3 grounds, Your Lordship. One is the hypertension, another one is the carrying angle, the third one is the poor dental point. And thereafter, the matter was referred to the review medical board, and the review medical board only for 2 conditions, his candidature was rejected. One is the hypertension, another one is the poor dental point, Your Lordship. But in connection with this case, Your Lordship, they have filed an affidavit in
As agreed to by the Learned Council for the parties registry to list this matter again on 17/7/2026. We'll see. Today it's 4:30.
Yes.
No petitioner. None appears for the petition. Oh, Mr.
My lord,
Professor.
I am appearing, my lord.
Ah, where are you? You are following the direction. Okay. Mr.
I am at
Professor,
home,
what
my
is your
lord.
case?
Today, in the morning I have gone, but
You are not in
my
Gauhati?
lord, they have taken. Yes, I am in Gauhati, my lord. But I went to the court in the morning, but I have come, my lord.
Okay.
I was,
That is the beauty of online. Yes. What is your case?
case, my lord. Learned friend requested me that they will take time today.
Okay, let them
That's
take
why
time. But what is your case?
my case is, my lord. I am eligible and qualified for the post of principal.
So show me the relaxation provision.
Relaxation provision, my lord. They have done the promotional exercise in recruitment,
This
my lord.
is not a promotion. This is a direct recruitment.
Direct recruitment. But
15th
instead of
begins.
instead of conducting direct recruitment, my lord, they have conducted promotional exercise.
Okay, fine. Be that as it may, but they cannot do it. Mr. C. Sharma, Learned Council for the Learned Standing Council.
Dima Hasaji.
Dima Hasa, Learned Council appearing for the Dima Hasa authorities submits that he be granted time till. No. Give me a date. 3 weeks will not do. Give me a date. With the before vacations date. Mr. C. Sharma appearing on behalf of Mr. R. Kaushik, Learned Standing Council, Dima Hasa Autonomous Council, submits that the affidavit on behalf of the said council authorities would be filed on or before on 24/6/2026. No further adjournment shall be granted in the matter. Registry to list this matter again on 30/7/2026 along with the said affidavit. Let them come, we'll see.
Highly obliged.
None appears for the petitioner on call. Aims of justice, registry to list this matter again after 4 weeks.
May I please? In this case, what happened, my lord? The respondent number 3 is not appearing, my lord. In spite of serving notice to him, my lord. Last occasion also, my lord, this was issued. We have taken steps, my lord. And what yet?
Who is appearing for RMSA? You were supposed to intimate respondent number 3. Have you issued a letter to them? It is submitted by Mr. B. Chaudhary that he had telephonically intimated the respondent number 3 that is the Managing Director, Adarsha Vidyalaya Sangathan, Assam, Kailipara, about the pendency of the case and that the case is fixed today. It is seen that there is no representation on behalf of the respondent number 3, in spite of such intimation being made on behalf of this court on the request of this court by Mr. B. Chaudhary. Now what to do with them? Proceed. Also, accordingly, this court will now proceed with the matter basing on the materials available on record. Registry to list this matter again on 15/7/2026.
Lord, office net shows that my lord, no AD, no response from the office number 22, my lord.
Seen the office note dated 4/6/2026, which reveals that the service report upon the respondent number 3 is still awaited. Also, registry to await completion of service upon respondent number 3 for 2 more weeks. Mr. P.K. Bora, learned counsel, appearing for the respondent, submits that he be given time till 16/7/2026 to place before this court the approval, the sanction of payment of the dues receivable by the petitioner.
Please, Your Lordship.
Yes. Complied.
No, Lordship.
Complied.
No.
Complied by not I received.
The A. Fukun, learned standing counsel, elementary, standing counsel appear, A. Fukun, learned counsel for the respondents, submits that respondent, the directions passed by this court wide order dated
6/5/2024.
6/5/2024 in WPC number 7265/2021 would be
That's when paragraph 16 of the order. They have been asked to not have a high power committee.
would be complied with within 10 days from today. Registry to list this matter again. 19. Mr. Fukun shall place before this court the compliance order on the next date.
Hello, please.
On the prayer of Mr. P.K. Bora, registry to list this matter again on 22/6/2026. On the next date of listing, Mr. Bora shall place before this court the compliance report. 23 Goidia. (48, 49, 50).
My lord. The case is relates to opening the portal, my lord. I have obtained the order long back, my lord. Till today, nothing has been done. And they have always, my lord, I am very unfortunate because they have bring something, my lord, and place place before your lordship. I haven't listened to it.
Hands flying. Oh, accident. Be careful, Mr. Sharma. Be careful.
The director has submitted the secretary.
What time you want, my Mr.?
No,
Because this is a case of opening the portal, my lord. That portal was opening up to 2024, 25 and 26. They have stopped the opening the portal, and that case, that school was opening since 2005, my lord. Very unfortunate.
2 weeks may be granted.
No, no, not 2 weeks.
or 10 days.
क्यों करने लगे? What for?
Report has been submitted to the government and government will verify.
You are always
Thereafter,
This is a contempt, my lord. This
Okay, show me the order.
Yes, my lord.
Where is the relevant portion? Violation which is okay.
Yes, my lord.
Yes, why have you not considered within 3 weeks?
this is my instruction, madam.
Forget your instruction now. Why consider?
Conducted, madam.
What?
Director has already conducted the hearing regarding verification document and other.
Oh, that was to be done 3 months prior.
Hereafter, my lord, it has submitted to the government, madam. And so
When did you submit to the government?
my instruction.
When did you submit to the government?
I can
No.
get the compliance order.
This order was passed on 7/4/25. What were you doing till now? Show me.
And it was, order was that within a period of 3 weeks.
I don't want that. You tell me. 7/4 you got the order. After that, what did you do? 14/5 you got the order. What did you do after that? Forget that. I don't want that. Give it back.
No. Sir, passing the order.
So last 1 year, what were you doing with regard to compliance of this order?
After order is on 34/5. A detailed report in respect of Manulapur SS School and my lord Tumni SS School and Gaurnagar Madrasa SS School and Mohesh Chandra Academy School and Ratidha SS
Ratidha.
School and Bimola Prasad Saliha SS School. Along with others, 17 numbers of school has been submitted to government while office letter number so and so dated 9/4/2000.
So 29/4/26. And the order was of
Yes,
7/4/25.
But prior to that, a hearing was also conducted.
Hearing conducted on when?
Yes,
Petition control.
on 23/2026.
23/2/26. So from 7/4/25, 3 months time, what did you do?
Hereafter, that.
No. Immediately 3 months, what did you do?
Yes, madam. Thereafter, that report was forwarded to the government for their consideration. On
Today we have no time.
2026.
We will consider this. Give me a breakup list of dates from on receipt of the order. What steps did you take within 3 months? We are drawing up contempt otherwise. Bakihini likha. As agreed to by the Learned Council for the parties, 3 48, 49, 50, belek ke mat. Same order is involved.
Yes, my lord, same order.
Registry to list those matters again. Immediately after vacation. 13th. No admissions in the no. The time is
Well, keep this matter as a part of then, my lord. Since
contempt.
you
You
all
can't
also-
keep part.
Oh, contempt. That may be
If it was
fixed then.
not for me today,
My lord, that,
you would
that
have
may be fixed.
Mr. Roy would have been injured.
Wait, please. 13/7. No, 13 opening.
How do I dare not give a date?
Nah. So. Highly obliged.
One lordship, long pending litigations, 2001 lordship. We finally
As
got
agreed to by the Learned Completed. They've
No,
given.
no, Lordship.
Why reinstatement is not being given, Mr. Bora? There is a clear-cut direction. Have you gone up on appeal? Register to list this matter again on 22/6/2026. Mr. Bora shall complete his instructions by that time. Today it's not there. We'll see on that day.
Lordship.
And there is a clear-cut direction, reinstate.
Lordship.
And still,
On all late 50s, your Lordship. Hardly any years left.
pathetic. These are orders of your court also. বাকি কিটা ডেট লাগে যদি ডেট দি দিবা বন্ধ পিছত দিব
My lord, in item number 58, my lord, there was a review petition, lordship. In that case, state filed a review, my lord. But last occasion, one writ petition also tagged with that, my lord. In that writ petition, that was dismissed. And again, they have filed for a restoration of that petition, my lord, in another court. It was tagged before the Honorable Justice Surana sir. So, my lord, on last occasion, the government
What do you want?
government has made a submission, lordship, that there was a status quo order. That is why last occasion.
They are not hearing anything. You want a date?
No, but lordship, this should list before Justice Surana.
It has already been ordered. It will be before the concerned bench, taking up bench too.
Review is there, my lord.
We be that as it may. It has already been ordered by my Lord Justice Surana, and it has been approved by the Chief Justice.
It's a 2013 matter, my lord.
We'll have it sometime in December. 13 years, pura. As prayed for by the Learning Council for the parties, registered to list this matter again on 16/7/2026.
Can it be on 19, my lord?
19/7/2020. 19. Where? We hold it. You are holding. You will.
16 July.
We can come. There is no problem. Sunday.
No, I was thinking 19/6 because the old matter, my lord. Because of that reason.
19/6.
Lord.
Yes, Mr.
60. If a date may be fixed after vacation.
As agreed to by the Learning Council for the parties, registered to list this matter again on 27/2026. Yes, Mr. Soma.
Item 54, date.
54. What did you have data? It's a promotion, head assistant promotion.
For vacation, for vacation.
এই কাগজখিনি কি আছে চাই ল'ব দে